Joan Mellen is an author and professor emerita from Temple University. She has written 24 books, among them A Farewell to Justice, Our Man in Haiti, and The Great Game in Cuba, which explore the history of the Central Intelligence Agency and its role in the planning and cover-up of the Kennedy assassination. Her latest book is Blood in the Water, How the U.S. and Israel Conspired to Ambush the USS Liberty, and that will be released in November of this year. We're going to talk today about the Supreme Court case Garrison versus Louisiana. The oral arguments are available as MP3s from the National Archives, and we'll play them after this for people who are interested. But I think the interesting part here will be hearing Joan Mellen, who is the biographer of Jim Garrison. She wrote a book called Jim Garrison, His Life and Times. And Joan will give us the context of the court case and maybe tell us a little bit about Jim Garrison's tenure as New Orleans district attorney before the Kennedy case came along. Thank you, Joan, for speaking with us today.
Thank you, David, because this is the first time anybody has actually asked to talk about the Garrison versus Louisiana. And it's the most amusing and interesting, and it shows Garrison's character and his beliefs and what kind of person he was. And this is all before the Kennedy assassination occurred even. What do people say? Who is Jim Garrison? He's been criticized so much. He's been, even by people who are supposed investigators of the Kennedy assassination, such as, well, I'll name one, is Peter Dale Scott, who lied about Garrison for 50 years and said that Garrison was attached to the mafia. But if you look at the life of Garrison and the cases and what he did, you see that he had nothing to do with the mafia whatsoever, never took money from anybody, and there are dozens of people that can confirm that. He didn't care about money. He spent money whatever he felt like, and he never had any money in his pocket. When he went out with somebody, they had to pay, and that was just the way he was. He just lived his life. So the whole idea, it's just so wrong. Now, things were going on in New Orleans. I'm not saying no, but none of Garrison saw them or was aware of them. And so it shouldn't be surprising to anyone that this district attorney in New Orleans should suddenly drop everything, drop all his cases, and devote himself to the Kennedy assassination, because he was a person of principle and morality, and he cared more about the First Amendment than he did about any money or whatever was going on in New Orleans. He didn't care. He didn't care about anything. And we can see that. The proof of that is the whole story of Garrison versus Louisiana. I'm so thrilled that it's actually on tape now and people can listen to it. And it's very funny because the whole thing was filled with Garrison's sardonic humor and his attack on the 8 judges of the criminal court in New Orleans.
Maybe let's start with what was going on in New Orleans that kind of brought the whole thing up, and then we can talk about actually what caused the conflict.
Question. Perfect. Because when Garrison took office in May of 1962, he decided that he was going to make his mark by cleaning up the French Quarter. And they were fleecing people, getting people drunk, taking money from people, whatnot, in the clubs, these various clubs. And women were seducing men into bee drinking. Bee drinking means drinking for the bar. And Garrison and his office staff decided that they were going to clean up these clubs and close them down, padlock them, and make the quarter a safer place for people. Now, it didn't turn out quite that way, but that was what Garrison said, and also, of course, to make a name for his office as he was the new district attorney at that very moment. So he got involved with how do you finance this? Because, for example, he had to pay investigators from out of town to come in after a while, because the investigators that came from the office got to be known in the clubs. So when you could see them coming, then you would clean up and you wouldn't be doing these crimes, and you couldn't get anyone. So how do you finance it? So Garrison there was something called the Fines and Forfeitures Fund. That means if you don't pay up your bail bond, or if you're assessed a fine in court, this money all went into a pot that was supervised by the 8 judges of the criminal court. And Garrison would apply for this money in order to fund these investigations. Now, previously, any crime that was investigated or was not investigated was done by the police department. So Garrison his office then took on the role of being a constab. What's the word? Constab, kind of like constables.
Right.
And nobody had given them that right to do that. So there was a big fight with these judges who were corrupt, who were using this money for themselves, and Garrison got into a fight with them over this. He also wanted to. The office that he inherited from Richard Dowling, his predecessor, was all filled with filthy old furniture, broken down, dirty carpets, and he decided he was going to refurbish the office at the expense of the Fines and Forfeitures Fund. And he was not scrupulous in getting bids from various places, whatever. It's not that he took money; it's just that he didn't abide by these norms. So they refused to give him the money. The judges refused to hand it over, and Garrison he used the press. That was one of the things that he did. Whatever he did, including the Kennedy investigation, he used the press on his own behalf. So he goes to a luncheon. I think it was a B'nai B'rith or something luncheon, and he attacked the judges, and he called them the sacred cows, like the sacred cows of India. They could do no one would criticize them no matter what they did. They were not answerable to anyone. And he called them the sacred cows of India. Then he said that they were subjected, they gave in to racketeer influences. Now those are fighting words in New Orleans in that day. That they were controlled by racketeers, which they were. So he said that, and then he accused them of being vacation-minded, and they celebrated. This is Garrison's humor. They celebrated Huey Long's birthday. They celebrated something called Winterbottom Day. I don't know what that is. Various, he exaggerated a little bit on that. He also said that they didn't work on Fridays, especially the leader of these judges, whose name was Bernard Koch. So this was very funny. Everybody was laughing, and the judges demanded an apology from Garrison, and he refused to give it. And that was what led up to the moment when they sued him for criminal defamation. That was how this started. So he's enjoying the whole thing, and they actually go to court on this. Now, Garrison had a weak link also. He had his chief investigator was a former police officer and criminal type, is the word they used in those days, called Pershing Gervais. And they used that as a weapon, but didn't work. Garrison just didn't care, and they went to court. And Garrison had a very upright, very interesting lawyer called Donald V. Organ, and he was very smart and very upright. So he goes to court, and every one of the judges, 8 of them, take the stand. Well, while Garrison is sitting at the table, he writes a play based on Shakespeare. He was very interested in Shakespeare. Garrison's main ambition was to be a writer, and he wrote 3 books in his day. So he's writing a play called King James the First, and it has to do with 8 noblemen, all based on each one on an individual judge, who were corrupt and were against King James, that's himself, and he got it all in Shakespearean style. It was hilarious. It's really good. So anyway, it's available in the Garrison papers in the National Archives, if anybody wants to see that. So he's writing this play, and he loses the case. They bring up Gervais and his problems, and he loses. And don't forget, he's not in control of the courts, and the judges have friends everywhere, and he loses. He appeals, and he loses the appeal. And then this doesn't bother him. Meanwhile, in the course of this, Garrison had a mentor called Eberhard Deutsch. He was the first person that he worked for when he was a lawyer. And Deutsch was very highly placed, influenced, had friends among the justices of the United States Supreme Court. So Garrison has to tell Donald V. Organ, who had written up the whole case up to this point, that he'd like Eberhard Deutsch to argue the case. Well, first of all, it had to get certiorari, right? And this was very interesting. Lucky for Garrison, that in March of 1964, the United States Supreme Court passed New York Times versus Sullivan. And that's a very big case, in which guaranteed the right to criticize people in the press, so long as there was no malice. The standard that now was malice aforethought.
All right.
Now, Garrison's case fit as a coda to this case, because Garrison's case was that you should have the right to criticize public officials, like the judges. The judges were public officials, and that was as part of this. These are expansions of First Amendment rights. So the justices were very happy to get the Garrison case because it fit right in. This is the Warren Court now. Earl Warren, shortly to supervise the Warren Commission, is the Chief Justice. And among the others are William Douglas, very interesting liberal people, and William Brennan, the great First Amendment lawyer. So Garrison goes there to Washington. Eberhard Deutsch pays him $5,000 so he can go to Washington. He had no money, nothing. And he's sitting there looking, and he says, he looked at the justices on the United States Supreme Court, and he says 3 were district attorneys. So see, I had 3, this is Garrison's, I had 3 going in, he says. And his friend, Robert Haig, H-A-I-K, went with him and said, you lost. After we hear the arguments, you lost. And, of course, he didn't lose, did he? And he won, and the majority opinion was written by William Brennan. It was one of his great opinions among First Amendment cases. Now, the person who represented the state of Louisiana in the case was called Jack P.F. Gremillion, and he's a real country bumpkin.
Yes.
At one point, he called the case grave. So Garrison says, this is a quote, if this was Hungary, Russia, or someplace, Garrison said, it would be grave. But this is America. Have they forgotten the First Amendment? And, of course, Gremillion was a kind of ridiculous figure, but he was well planted. He was a protege of the brother of Huey Long called Earl Long, a big figure in Louisiana during that time. And Long once said about Gremillion, this is a great quote, I couldn't resist, if you want to hide anything from my Attorney General, Gremillion was the Attorney General, if you want to hide anything from my Attorney General, just put it in a law book. So what Garrison commented at the time was about the things that he said about the judges. People say worse things about President Kennedy every day. Isn't that? And, of course, how would he know? Kennedy was shortly going to die, and all the rest that would follow.
Right.
So people told me about that, the business at the Supreme Court. Gremillion goes in there, his pants barely to reach his ankles. You know, he really looks like a bumpkin. And Garrison's lawyer, that's Eberhard Deutsch, had a vest and pinstripes and fancy, very fancy.
Right, and that's who we'll hear, just so people know it's not going to be Jim Garrison or anything doing these arguments. It's going to be Deutsch and Gremillion. Right.
Would be Eberhard Deutsch for Garrison, and Jack P.F. Gremillion, also called General for the state of Louisiana. And when Eberhard Deutsch went into the court, he said hello to all the justices as if he were a personal friend of theirs. And when he said when Gremillion said the justices have been criticized vociferously in my state, and he was referring not to the justices but to Judge Jake Skelly Wright, who had ordered just this very moment the desegregation of the New Orleans schools. You can imagine how the Supreme Court felt because they were supporting their own decision of Brown versus Board of Education. And here's this guy. It just was perfect for Garrison. It was a Warren Court. And they were liberals, and Garrison was a liberal. So there wasn't going to be any. He had a lot on his side.
Right.
One of the interesting things about William Brennan's opinion on this case had to do with his statement. I'll read it. Erroneous statement is inevitable in free debate. It must be protected if the freedom of expression is to have breathing space to survive. And that really means the issue of libel. It doesn't depend on whether you're erroneous. You can't be accused of defamation if you make a mistake. If your statement is erroneous, you still have the right to make that statement. And William Douglas said in a concurring argument, it is a commonplace of life that heat and passion subtly turn to malice in actual fact, and Garrison's utterances did not meet the rigorous standard of malicious intent. That's part of New York Times versus Sullivan. But you needed the Warren Court to have his very enlightened views, and I don't think we'd get those views today. Do you?
No, I don't think so, and I think
this
we'll
other
be
clown that's about to get in there. But
exactly.
These are William Douglas. I mean, these are very distinguished people, and Thurgood Marshall wasn't even on the court yet.
Right.
And so that's really the background for the Garrison versus Louisiana. Another thing that Garrison did that I want to mention is he went as district attorney. One of the white, what they call citizens' councils, attacked a junior high school civics teacher for using Max Lerner's book, America as a Civilization. And he was accused of communist philosophy. And Garrison refused to prosecute that case. People forget about what he really was like, or if they ever knew. Maybe they didn't know. That really he was, that was what he was most interested in as district attorney, to protect the rights of people. You never would have thought. None of this was predictable in the Louisiana of that day, which was corrupt, which was filled with graft and under the table and all of this. But Garrison never took money, and he really was a man of principle, and he used the office of district attorney to support his principles. For example, he prosecuted the cases where Klan bombed people that they didn't like, Ku Klux Klan, and these would usually never prosecuted. Garrison prosecuted them. Another case that was related to this was a case in the Doubleday bookstore. The police went into the Doubleday bookstore and they arrested the manager of the store for obscenity because he was selling James Baldwin's novel Another Country, and so forth. And Garrison had a very strong reputation. He also, of course, had the black vote in New Orleans because he was always fair to everyone, and he was not a racist. Right. He wasn't born in the South. He was born in Iowa. And his father and mother, they were not from the South either. Now, his mother took him and his sister, when he was a child, to New Orleans, as she was divorced from the father, and she was trying to earn a living there, and so that's how he grew up in New Orleans. It wasn't because he was out of that, he didn't come out of that culture. So he was a loner. He was, he was kind of an outsider as a kid, and also poor, very, very poor. And this is the foundation of the person that you see in the Kennedy assassination investigation. Because why would he do it? And nobody might understand that he would do it because he said it was in my jurisdiction.
Right. Well, it's interesting to compare him.
Sorry?
It's interesting to compare him and his attitude towards justice with someone like Henry Wade, who we've all seen and who we all know has had so many of his convictions overturned and was basically a hangman and was this kind of brutal Southern district attorney compared to Jim Garrison, who, the way you show him, is 180 degrees.
Absolutely no comparison. And Garrison was a man of principle. He gave long speech. He gave a lot of talks during his day, and one of them had to do with the First Amendment itself. It said he compared the First Amendment to a patient in an oxygen tent, and the oxygen is cut off, and you constantly have to revive it, and you have to, because it was always to be, in other words, being challenged.
Right.
And that was what interested him, really.
Do you want to talk a little bit about what some of those judges he was up against were like? You said they were pretty corrupt.
Bernard Koch was the worst. He never was in on Fridays. He did what he pleased. He used to come to the office, to the bench, naked under his robes. It was very hot, and that wasn't air conditioned. And he just did what he pleased. He couldn't stand Pershing Gervais. He couldn't, who was corrupt, was a terrible person, terrible. But so Judge Koch was the leader of the group. But then there were others, some of them ordinary, some of them, I can't remember all of them, but I sort of discussed them, all racists, needless to say. And they couldn't understand anyone like Jim Garrison. Judge Haggerty was among the group, who later presided over the Clay Shaw case. And the judges were also, they were drunks, and they depended upon the police to protect them. So in other words, if the police spotted one of these drunks out on the streets, they would put him in the police car and drive them home to protect their reputations. So that was another side of it. They were not great friends of Jim Garrison, ever.
But Garrison was kind of a shock to the system, because he, as you describe in your book a little bit, he basically came in, he won, he beat the old DA based on this televised debate.
The debate, right.
I mean, he was almost completely outside the system, and they didn't know what to do with him, basically.
Well, one of the biggest parts of the system was this bail bond corruption. And Garrison took, didn't take any money from anybody. He wasn't supported by any political party. He was the first district attorney never to be supported by a party, Democrat or Republican, and that meant that when he got elected, he wasn't beholden to anyone, and he acted that way. He wouldn't prosecute sex crimes, for example, and what they called crimes against nature, which meant homosexuality then.
Right.
And people who have said that he arrested Clay Shaw because he was gay is just not true. He didn't even know it, but then eventually did know it, but it didn't make any difference to him. Had nothing to do with it. And he made a rule in the office never to mention Clay Shaw's sexual preferences in court in any way, in any papers or any proceedings. And he abided by that. I think, when you look at it, he was not perfect. He was not a perfect person, as he himself said, when he was framed by Pershing Gervais for taking bribes from pinball operators. It was illegal to pay off on a pinball game, but with the bartender in a bar. And so money was planted, and Pershing was somehow involved with this, and Pershing eventually taped him, and they doctored the tapes. Pershing went to Canada on a witness protection, and Garrison was accused of corruption. Went to court, a federal crime, and there was a reporter in New Orleans called Rosemary James. I think she's still there, but maybe not still a reporter. Anyway, she smelled the story. She went up to Canada, and she interviewed Pershing Gervais, and he admitted to her that he had lied. And he planted this money in Garrison's desk, and Garrison never did this. So Garrison eventually was acquitted. But he had to fire his own lawyer. Eventually he represented himself, and but it cost him a lot because he was exhausted, and he didn't want to campaign. He was up for re-election, and he didn't want to. It was in I think 72 or 3. He didn't want to campaign, and he didn't like to campaign at all, ever. And so he lost by 2,200 votes. So the person who succeeded him, that was the father of what was that folk singer?
Harry Connick Sr.
Harry Connick. So Harry Connick gave out cufflinks with the number 2,200 written on them to stand for the 2,200 votes. And that's how he defeated Garrison. And that's how Garrison lost his office. Well, once Garrison lost his office, he could no longer investigate the Kennedy case, because he was relying on the office and investigators and that he had through the office. So that he had to do it much more slowly. He never gave up investigating, but that was about the end of it.
Tell us about your latest book, Blood in the Water.
So it was in 1967 during the Six-Day War. The ship was the USS Liberty, which was a surveillance ship. That it was unarmed. It only had a couple of machine guns on the deck. It didn't have any. It could not defend itself were it attacked. And they're floating along there in the East Mediterranean, and there's Soviet ships all around, and that's part of the book. But suddenly, on the morning, or rather on the afternoon of June 8th, 1967, Mirage planes, jet planes with machine guns and rockets, and then other planes, Mystère, these are French planes, with napalm. Where'd they get the napalm? And they threw the napalm on the decks, and they start firing on anything that moved. People, sailors, anyone standing around would get shot.
Mm.
And the place is a bloodbath. And was very lucky that one sailor, that was the sailor in charge of the antenna, they had all these antennae on deck, and the Israeli planes, the planes were unmarked. They were blacked over, so you couldn't see to what country, even though it was a violation of international law, not to identify yourself. It's marked out black. And one antenna is not, that escapes being destroyed. And there was one sailor called Terence Halbardier, and he manages to hook it up to whatever it is that they get hooked up to. And they managed to call out an SOS, and they reached the Sixth Fleet. And as a result, the plan was for the Israelis to sink the ship and everyone on it, and they were going to then blame Egypt, because the CIA, various figures in CIA like James Angleton,
right,
and others were they had it in for Nasser. They saw Nasser as a big threat to the United States, and so they were going to blame Egypt for all of this, and then bomb Cairo. And it's really not known. Nobody knows. There's no proof. Nobody has known that they, in fact, did send planes to bomb Cairo. And at the last minute, the SOS goes out. The Israelis tap in. They realize that they've been discovered. And so they have to call back the planes from Cairo. There was 7 minutes from target. Had to call back to the Sixth Fleet. But meanwhile, the Sixth Fleet, there was one honorable captain called Captain Tully, and he sent planes to the Liberty to help them because he heard the attack on the radio. And then Lyndon Johnson twice, once McNamara, once Johnson, called back the rescue planes. So that nobody goes to rescue the Liberty. And to make a long story short, they overnight, they're all alone, they're bleeding, dying. They have one doctor on the ship for 300 men. And nobody comes to their rescue until the next day. This is all covered up. And Lyndon Johnson directly got on the phone and said, call back those planes. Why did he do that? Well, that's the story. What happened? Why was Johnson in the middle of all of this? And nobody, and Israel has covered up. It's not that the United States covered up for Israel. It's that Israel has covered up for the United States. Israel took the blame. They said that it was an accident. They made a mistake. They thought it was an Egyptian freighter with horses that carried horses, and a bunch of nonsense. Why would they attack a ship with all these antennae and satellite dish and everything else if it were an Egyptian horse freighter?
Right.
But anyway, they didn't care what anyone thought, as they even to this day they don't. And so there's going to be, I suppose, I don't really care who says what. As I'm like Garrison now, but they're going to attack me for this. But the proof is it's unmistakable. And I even found a great piece of evidence, which I'll share, why not? And that was in the report of the Joint Chiefs. The Joint Chiefs sent out a team to investigate the firing on the USS Liberty. And in the course of that report, which is available in the National Archives, you will see that who sent the ship to be in harm's way up there. There was no reason for the ship to be in the East Med in the middle of the Six-Day War. And we find out that the person who was directly in charge of placing the ship was Cyrus Vance, who was a close operative of Lyndon Johnson and was assistant defense secretary. His name is in there. They should have redacted that, see, but they sometimes all this redacting, sometimes something slips through, and the truth comes out. You have to work years in and year out, and read everything and look at every document, and sometimes you get the truth. It's amazing that that's in there.
So, and James Angleton was involved in.
You see well, you'll see. I have the conversation that led to the firing on the ship. and that was the head of the Mossad, called Meir Amit, A-M-I-T, M-E-I-R-M-A-M-I-T, Meir Amit, and he came to the United States a few days before the Six-Day War started, and guess who the first person was whom he saw? An old friend of his. That was called James Angleton.
Hmm.
It was only after Angleton was much more important in this that Amit went to see the Director of Central Intelligence, and that was Richard Helms. But in later years, Helms came out publicly, very rare for Helms, and said it was not a mistake, it was not an accident, it was deliberate, and he was very indignant about the whole thing. But that's an interesting part of the story. You don't see Helms giving away anything, in the history of Helms.
Oh,
there
no.
he is, giving the truth.
Wow.
So I had fun with that.
Well, great. So that comes out in November.
Comes out at the end of November. The publisher, I'll give the name of the publisher, Prometheus Books.
Great. Well, we look forward to that, definitely. Well, thank you very much for talking. I really appreciate it. And now here is the audio of Garrison v. Louisiana. It's actually in two parts. Each is a little more than an hour long. The first one is from April 22nd, 1964, and the second hour is from October 19th, 1964.
Number 4, Garrison, Jim Garrison, appellant versus Louisiana. Mr. Deutsch.
Chief Justice, may it please the court. It will be recalled that the appellant in this case is the district or prosecuting attorney for the Parish of Orleans, which is coextensive with the city of New Orleans, that when he took office something over 2 years ago, he launched an attack on a backlog of criminal cases awaiting trial, and at the same time embarked on a campaign against commercialized vice in the Bourbon Street district of New Orleans. That a dispute arose between himself and the judges of the criminal court after he had been in office for some time as to his use of certain funds for these vice investigation conditions, that the judges adopted a rule that 5 of them would have to concur in approving his vouchers for these expenses as against the statute which provided that any one judge could do it, that they then adopted a further rule allowing him no further expenses for that purpose out of this fund, that a recently retired judge made a derogatory statement concerning him which was published in the press, that he was asked to by reporters if he had any comment to make, and in reply made the statement which is the issue of this criminal proceeding for defamation under the Louisiana Defamation Statute. He stated that the judges were themselves responsible for the backlog of cases, that they were not working, that they were taking excessive vacations, that they were endeavoring specifically to block his investigations of commercialized vice, which, quote, raises interesting questions about the racketeer influences on our 8 vacation-minded judges, and this proceeding arose out of that on a petition by the judges to the Attorney General of the state requesting him to institute criminal proceedings, charges against the appellant under the Louisiana Criminal Defamation Statute. And on the same day that he did that, the Supreme Court of Louisiana appointed a judge from another district to hear the case. Trial by jury was denied. Motion for trial by jury was denied under the Louisiana statute, which provides that juries are not to be used in misdemeanor cases, this being a misdemeanor, and his pleas properly presented under the First and 14th Amendments were overruled. He was found guilty, and the judge said that he would be less than frank if he did not say that the defamatory statement might not have been issued without some provocation, and under the mitigating circumstances, as the judge put it, levied a fine of $1,000 or, in the alternative, a jail sentence of 4 months.
Mr. Deutsch, was the jury trial demand predicated on a federal constitutional claim?
It was on the federal Constitution, yes, because the Louisiana Constitution specifically provides that you may not have a jury in a misdemeanor.
I mean, in terms, was it?
It was predicated on the Sixth Amendment, actually. It should probably have been predicated on the First and 14th. That's the position we take here. The Supreme Court of Louisiana did specifically pass on the point that it was not necessary to furnish a jury in this case under the First and 14th Amendment. The Supreme Court of Louisiana affirmed the conviction, passing on the specific constitutional issues which had been raised, and relying primarily on this court's opinion in Beauharnais versus Illinois that libelous utterances are not within the area of constitutionally protected speech.
Is the appellant still in office?
Yes, sir. The judges and he have made up, if that's of any interest, at least 6 of them. They're getting along fine now, and each...
That doesn't moot this case, though, does it?
No.
Calendar situation improved?
Pardon?
Has the calendar situation improved?
I understand it has been, that it's very difficult to furnish adequate statistics. I've been interested in asking that question myself, because, for instance, the result of this vice campaign has increased the docket considerably, and to get up statistics which are meaningful is difficult. There are still many cases on the docket, but there have been many more cases tried than ever before. For the first time in history, the judges are now holding court regularly on Fridays, which they were not doing. They are trying jury cases at times when they were not trying them before. They have cut down this vacation period, which the record shows arose in 1921 before there was air conditioning, and in New Orleans it was just too difficult to get these cases tried in a non-air-conditioned courtroom, that now the courtrooms were air-conditioned but empty, while the jails not air-conditioned were filling up rapidly, and so on and so on. That condition has improved tremendously.
Has Mr. Garrison stood election since?
Pardon?
Has Mr. Garrison stood election, been re-elected, or have they had an election?
No, he remains. He was elected, I think, for 4 years, and his term has only run something over 2 years at this time. Now, there have been other elections down there in which he's been involved, as between the judges and himself. I suppose that may be an answer to your question. He's been successful. He's had popular support for this campaign. Now, in this New York Times case, the Beauharnais case was at least distinguished with a statement that the Constitution does not protect libelous publications, that the statement in the Beauharnais case to that effect, do not foreclose inquiry into cases which might involve the use of libel laws to impose sanctions upon expressions critical of the official conduct of public officials. Now that brings up something that's not in the briefs. It just happened a few days ago. But there have been 2 other prosecutions in Louisiana under this statute very recently. One of the cases, or at least a forerunner of one of those cases, is on this court's docket. I think it's numbers 24 and 49. They're coming up as a part of this a set of cases now, Cox versus the state of Louisiana. Now, arising out of that case, the Supreme Court of Louisiana a few days ago denied a rehearing. And I think this is particularly significant in 2 cases involving prosecutions under this same defamation statute. A Negro minister was stated to have defamed a court, that is a judge and the district attorney in Baton Rouge, Louisiana, by casting aspersions on the court's conduct with regard to prosecution of Negroes. And he was prosecuted under the defamation statute, convicted, fined in each case the full limit of the allowed under the statute of $3,000 plus 1 year in jail on each case, making 2 years plus $6,000, and then required to serve an additional 2 years if he didn't pay the $6,000. Now, the case came up to the Supreme Court, which wrote a considerable dissertation on the effect of this court's decision in the New York Times case, stating that its defamation statute was entirely valid, and this prosecution was entirely valid under that statute, but and then after that, in a short part of the decision, reversed the decision on the ground that the district attorney had not recused himself because he was, in a sense, a party to this prosecution. What I'm getting at is that this is being used. This statute is being used. The number 24 and 49 on the docket of this court right now is the case out of which this prosecution grew. The citation of the case is State of Louisiana versus Cox, C-O-X, B. Elton Cox.
You say that's 24?
No, well, the prior case is number 24, the case out of which the prosecution arose. The prosecution for
those cases that we have on the argument list this week, though. You speaking of the Cox cases on the argument list this week?
Right.
That demonstration before the courthouse and so forth?
That does not bring up this defamation prosecution.
But I think you said it grew out of that incident.
That's correct.
Now, and there's been since a Supreme Court decision bearing on the use of the defamation statute.
Well, actually, directly involving the defamation.
Well, now what's that opinion?
Now, that opinion is number... Well, it was decided on June 8th, 1964. It's number 47018 of the docket of the Supreme Court of Louisiana.
Well, isn't it published somewhere?
It's not yet published. Rehearing was denied October 7, just 10 days ago.
Well, now I have that number again.
47018.
Where are the opinions? Any way we can get copies of that?
Yes.
Well, if you all will give me time, I arrived in the United States yesterday morning from a long absence, and I will put this in the form, if you like, of a supplemental brief.
Well, I'm sure the Attorney General is indicating we can get them.
Yeah. I have no doubt of that. There must be copies available. I have only one copy. I'll be glad to print it up and file it with the court if necessary. But it demonstrates, I submit, the frightful use to which a statute of this sort can be put. A man is sentenced to 2 years in jail to pay a fine of $6,000 and an additional 2 years if he doesn't pay the $6,000 because he used language, however strong it may have been, reflecting on the judge and district attorney, and it happens to involve the identical statute. Now, James, I skim over a great deal of this simply in the hope of getting questions. We've been through it from top to bottom, I think. I call attention to the fact that James Madison, who literally drew the First Amendment with his own hand, said that it would be a mockery to state that you could not have laws preventing publications and still have laws punishing them when made. Our position is simply, certainly for the purpose of this case, that when a statute of this sort is used to support seditious libel, it is invalid under the First and 14th Amendments. Now, we could go further, of course, and apply it to all libel. I could go further and say that a jury trial is an indispensable necessity under the Due Process Clause of the 14th, carried over from the 6th, just as this court has recently been rendering its decisions taking the Federal Bill of Rights under the Due Process Clause of the 14th Amendment, that a jury trial is just as much necessary as a matter of due process in a state court as it is in a federal court. I don't have to do that in this case because, in my opinion, the history of prosecutions for contempt clearly indicate that a man is entitled to a trial by jury on a defamation charge, even if such a defamation charge may be made at all with regard to a public official.
Well, what's your definition of seditious libel?
Putting it very succinctly, defamation of a government official, of a public official.
Even in his personal capacity?
Well, perhaps not, but it's almost impossible to separate the two. For instance, if I say one of the judges of this court took a bribe, that reflects on both his official and his personal character. If I say that racketeering influences are brought to bear effectively on a judge, I don't think you can separate that from his personal,
Now, what have you said in the same breath? That he's a very fine judge, but he's a notorious adulterer.
Well, I would take it that adultery is not a characteristic of judges, and accordingly would refer to his personal rather than his judicial capacity. I think you've got the extreme there.
Would that be seditious libel?
I would think not. I can conceive, if I sort of use my imagination enough, that it might have something to do with a case he was trying or something of that sort. But by and large, I think there is a distinction, but there is a very broad shadow zone, I'd put it that way. It's awfully hard to say that a judge is subject to racketeering influences, and then say in the same breath that that does not refer to his official capacity. I can't conceive of that.
Deutsch, do I remember correctly from the record last time that the lower court judge here found actual malice in making this statement?
May I discuss that briefly for a moment? You will find references to that all through his opinion and his rulings. He admitted evidence to show malice of prior statements, subsequent statements, and so on and so on.
Is that the import of this recent decision of the Supreme Court analyzing New York Times?
This most recent decision probably goes a little further. It's an analysis of the New York Times case as applied to this case, and takes about 8 or 10 pages to do that, and then says we reverse anyway. I mean, it's dictum, clearly.
Isn't it necessarily your theory that even if actual malice is present when it comes to a criminal prosecution based upon defamatory statements of a public official in relation to, say, the official conduct, the statute cannot fit?
Well, that is my position, period, but I don't have to go that far to win my client's case if I can do it. Now, there was no actual malice within the meaning of this, of the Times case, and I would like to quote a few words from the trial judge's opinion, which I don't think are in the brief. They're on page 633 of the record. What he said was, I cannot believe that this man could have had an honest belief that what he was saying was true. He said that. And then he said, however, even were it conceded for the purposes of argument that he did have a reasonable belief as to the truth of the statement, I am still of the opinion that the state has proved actual malice. Now, he's got a complete contradiction insofar as this court's statement in the Times case goes, that actual malice involves a necessary knowledge that his statement was untrue or a reckless disregard of the truth. 633.
There was malice, the conviction would be valid, would it, under your theory?
Well, I don't think, no, if I understand you correctly, sir, under my...
There was malice. The court, this court found it was malice, we'll say.
I still say that under the First and 14th Amendment there can be no such thing as seditious libel. I could go further with Mr. Justice Black, but I don't have to for this case.
Well, you do go as far, though, as saying that, or do you, that under the 1st and 14th, there may be no criminal prosecution for life?
I don't make that statement. I'm willing to make it. I believe it. But for the purpose of this sake, there may be, I say for the purpose of this case.
Maybe no criminal prosecutions for the libel of a public official.
That's it. That's my statement for the purpose of this case. I'm willing to go further. These criminal libel laws are now being used, as I've demonstrated in the brief and a Columbia Law Review article.
Why may the public official recover damages then for the New York Times? I suppose he could recover damages for the libel of himself as a public official if he can make the necessary showing.
He can make the showing of malice, actual malice as defined by this court. He may, under the latest decision of the majority of this court, recover damage.
But you say that
it's a vast difference between using these statutes for blackmail in criminal prosecution. Although, when you start giving judgments for $500,000 and $3 million, you're doing even worse than, I suppose, except for the jail sentence part, you're doing worse than the fines, which are always...
We suggested something like that in the Times opinion.
The Times opinion.
You said it'd be a different rule on a criminal prosecution.
Pardon?
The Times rule would not apply, you say, in a criminal prosecution.
Oh, I do say the overall rule of the Times case does not apply to a criminal prosecution, that there may be no such thing as a criminal prosecution for defamation of a public official under the 1st and 14th Amendments.
What you're saying is that an actual malice test, as we defined actual malice in Times, would not save a criminal prosecution if it's for defamation of a public official.
I do
that
so.
On the ground that that's a seditious libel law, and that whatever may be the status of civil libel suits, the First Amendment precludes any criminal prosecution.
I do say that, and I add to it, as an anchor to windward, that there was no proof of actual malice in the sense in which this court defined it in this case anyway.
Well, actually, I've forgotten, but I had the impression that this statute makes truth no defense if, in fact, the defamatory statement is made with ill will, doesn't it?
In this new, you'll find a rather lengthy discussion of that point. That is correct, but you will find a discussion of it in this latest decision, which I have just given you, the Supreme Court of Louisiana.
Well, I'm just wondering if on the face of it, to that extent, this statute isn't inconsistent, assuming now the Times actual malice test applies to criminal prosecution. Isn't this statute on its face inconsistent with that constitutional test?
I don't think there is the slightest question about it on that truth point. There's no question whatever about it. Now, of course, there's no proof of truth of this charge in this particular case.
I'm just so I can be sure I understand your point. Is it that that the First and 14th Amendment protects anyone from prosecution who libels or slanders any public official in any manner?
Well, I'd say that for this purpose, and I don't want to get into your adultery case. I mean, I don't want to get off on a tangent.
You say he's a
certainly
he's a
in
good
his
city councilman,
capacity as a government official.
But he cheats on the golf course. He cheats his friends every Saturday when he plays golf.
Well, again, you're within that shadow zone because a man to do that isn't fit to hold public office. You see, the shadow zone is so broad to me that there is almost no way of separating a man's personal character from his public character. If he has a bad personal character, he's not fit to serve the public. Now, I can't go all the way with you. I mean, there are some things that, well, let's say gentlemen don't call vice. Others do. I say you can get way off on a tangent on this question, and I'm trying to avoid that. But when you speak in realities, as we're doing in this case, about stating that a judge is subject to racketeer influences, a judge is subject, you're not saying John Doe, then the judges of this court are subject to racketeer influences, you're not off even in the shadow zone. That's clearly in his public official, his capacity as a public official.
Would there be contrary to Chief Justice Hughes' position in near, wouldn't it?
Yes.
We'd have to
the opinion of this court is contrary to that, sir. That dictum of Mr. Chief Justice Hughes in the Near case was clearly overruled in the Times case. I read that actual language. It says those decisions no longer, the Beauharnais and other decisions saving libel. Chief Justice Hughes said that the public official always has his remedy under the civil and criminal libel laws. That's the effect of what he said. Now, this court said in the Times case that that doesn't hold anymore.
Oh, no. Did we? I thought we said it held that it is civil to the extent that there was proof of actual malice as we defined it.
Well, let me read what it said. I'll get the, I think it was...
You mean near, you mean...
In the New York Times case, this court held that its prior statements in the Beauharnais and other cases, that includes the Near
and they're all listed in the footnote, and including Near. Go on.
To the effect that the Constitution does not protect libelous publication, do not foreclose inquiry into cases which might involve the use of libel laws to impose sanctions upon expressions critical of the official conduct of public officials. Well, now, Mr. Justice Hughes didn't leave that kind of an opening in his decision.
But then we went on to hold, did we not, that nevertheless state libel laws are available to the public official if he can prove actual malice as we defined it.
If you hold that, I say you held it only for the purpose of civil libel.
Oh, yes.
And I say that there is a significant distinction between taking this Negro preacher and giving him 4 years in jail for saying that they're not being treated right by the judge and the prosecuting attorney, and giving somebody a right to sue for some actual damages under those circumstances. I make that distinction very frankly.
Mr. Dwight, let's assume the person who tells a deliberate and very damaging lie about the public official. He knows it's a lie, and he tells it anyway, and he does it for the express purposes of destroying the man's reputation. And there are people like that. Now, why shouldn't this fellow be open to criminal prosecution?
Well,
your only answer so far has been a label. That's seditious libel. That's a seditious libel law.
Well, I didn't mean to put it in the form of a label, except that I meant that the label had a meaning.
What is it?
Now, the meaning you will find, for instance, in John Stuart Mill, which was quoted, I think, by Mr. Justice Goldberg in the Times case, if I'm not mistaken, who said that in the broad field of public affairs, that is part of the game. Now, he said that a long time ago, that people unquestionably fail to tell the truth from time to time and know they're doing it, but they do it during the course of public discussion, and that in a democracy like that of the United States does not give a cause of action, certainly a criminal cause of action. So that's what I mean by it.
So really to serve the truth, we should protect the lie also.
Exactly. I go all the way on
give
that.
Constitutional protection to the known deliberate
I think
liar.
it was intended by the framers of the First Amendment that that should be the case.
You mean, Mr. Deutsch, that's the old notion that you can't stand the heat, stay out of the kitchen?
Exactly. I think that's part of public life in a democracy, and I think it's a good thing that it is. I'd like to reserve a few moments for it.
Mr. Chief Justice, Justices of this honorable court, I would like to say with all due respect to Colonel Deutsch that he has confused the facts in this matter, in this particular case, and with the court's permission, I'd like a few minutes to tell you exactly what the facts are and exactly how they came about, and I'll do it very briefly, and I think that you will find that the record bears me out. When a defendant in this case ran for district attorney, he made a public statement that this fines and forfeiture fund should be corrected. After he took office, he met with the judges, and this is in our supplemental brief. He met with the judges and discussed the matter with them and agreed that a better system should be worked out. Upon the misrepresentations of the district attorney, the defendant in this case, to one of the retired judges over the payment of a rug, a carpet, this judge wanted verification of the price of the carpet. He was refused the approval of this expenditure. The fines and forfeitures goes into a fund handled by the district attorney in Orleans Parish. In order to get money out of that fund, he sends a copy of an order over to City Hall, which is approved by the auditor, and then he takes it to one of the judges to have it signed. After this misrepresentation, there were several other misrepresentations, and this is all brought out in the record and in the testimony. So the judges, in order that their work couldn't be played against one another, they met and adopted this so-called 5-by-8 rule. Now, he knew all this at the time. He knew it when he campaigned. He knew it afterwards. And he knew that the statements he was making about being so-called being blocked by vice and so forth were in error, because of the fact that from the time that they met with the 5-by-8 rule, at which he was present, the judges approved some close to $50,000 of money for him to use in so-called vice investigations. In addition to that, he had 12 policemen assigned to him by the chief of police, and this is in the record, who were paid by the city, not out of his payroll, who worked at his direction. Therefore, there was no possible way that these judges could have blocked any investigation that he made. He had all kind of money. He had all kind of personnel, including his own investigators. So when he made the statement that they blocked his investigators, that is not true, and he made that statement deliberately knowing it to be false. Now let's talk about vacations. He said that they weren't working, that the jail was full. Well, the district attorney in the state of Louisiana controls the docket. He determines who, where, and when they will be prosecuted. The judges have nothing to do with that. Furthermore, in Louisiana, courts, just as this court, does not work on Saturdays and Sundays. That's 104 days out of the year. The Constitution provides that the courts will take, criminal courts will take 2.5 months vacation, which is another 75 days. There are 17 legal holidays. You add those up and it comes to 196, I believe. He claimed that they were taking 206 days vacation. Well, they had to take 197 days vacation. There's no way that they could do anything about it. And I think that this court realizes and appreciates that where you have a criminal district court without law clerks and without a library, that it's certainly going to take them some time in addition to sitting to look up the various legal points that come before that court. Now, knowing all that, he became irritated, apparently, at a retired judge's statement over the question of this rug. And he called a news conference on November the 2nd. And he just said everything in the world. But the chief thing that he said was that all of this so-called blocking his investigation and taking vacations and so forth, that this raised interesting questions of racketeering influence and no other questions. Now, after that happened, the judges filed an affidavit against him, charging him with defamation under the same statute that he is now being prosecuted. He had one of his assistants walk into court and dismiss that, which the district attorney has the right to do. Now, as I said to this court previously, and I say in my brief, here was a situation where judges were accused of being racketeers. And I agree with the court, or one of the justices that made the remark, that if he's guilty of that, he's got no business being a judge. So the 8 judges petitioned me, because I have authority over district attorneys, to come in and prosecute him on a bill of information. And it was their position that if what he was saying was true, they didn't have, and they were unfit to hold office. So I filed a bill of information because I thought that it was my duty. And I had to do it because that is the only way that the state can prosecute an individual. It's got to be done in the name of the state. If I walk over and I slap you, and you file a charge against me for simple battery, it's got to be in the name of the state, because the state stands for law and order. You can't take law into your own hands, such as your instance about saying he cheats at the golf course. What is that man going to do? Is he going to take a gun and go kill this fella? You can't do that in our particular society. So continuing, I filed a bill of information against him to give him the opportunity to prove his charges. After the bill of information was filed on November the 13th or 22nd, I think it was, he made a speech at a Catholic school meeting in New Orleans. And he went through the same charges. He accused these judges of being influenced by racketeers. He says there's no other reason. And he said that he was going to keep shouting to the public because he had no other allies, because the other officials belonged to the Association of Armed Robbers. And incidentally, in the meantime, he had told several reporters, all of which is in the record, that it wasn't nothing but a racket, that the only way he could put these sacred cows back to work was to tell the public about it. When I tell you that the record bears out that he knew that there wasn't any truth to what he was saying, and that he didn't have any reasonable idea or remote consideration that what he was saying was the truth. That what, Your Honor? No, I don't think so. Because I think that that statement would be one that may have been made in the reasonableness of the truth. Now, my statute provides this, that defamation is a malicious publication or expression in any manner to anyone other than the party defamed of anything which tends to expose any person to hatred, contempt, or ridicule, and to deprive him of the benefit of social intercourse. Now, it provides a privilege. An actual malice must be proved, regardless of whether the publication is true or false, in the following situations: where the publication or expression is a comment made in the reasonable belief of its truth upon A, the conduct of a person in respect to public affairs. Now, Mr. Deutsch was talking about the Cox case. Let me say that the two cases on the docket here this week are this calendar, number 24, number 25. One involves the right to picket in the city of Baton Rouge, which is not connected with this case at all. The other one involves the right to be issued a parade permit by the city of Baton Rouge, which doesn't involve this case at all. And the Cox case, which was decided by the Supreme Court, which is not reported, and I looked just before I came in, it's not reported even in the advance sheet. He was charged with defamation of a district judge for this reason, that he said it was common knowledge that oppressed Negroes who appeared in Judge Blanchard's court had to pay a fee which inured to Judge Blanchard's benefit to keep from going to the penitentiary. Now that's what he was prosecuted for. And one of the defenses, among others, that he made was that he had the right to say anything he wanted about a public official because he was protected by the First and the 14th Amendment. And our Supreme Court went into this matter very thoroughly, and here's what it says. It says, we cannot agree with the appellant, therefore, that the New York Times case, talking about the Sullivan case, is authority for holding that a condition that the publication or expression must be made in the reasonable belief of the truth for the privilege to apply violates the constitutional safeguards of the First Amendment. We view our statute as being fully in accord with the New York Times pronouncement, conceding that case of civil libel is applicable to our criminal defamation legislation and is fully safeguarding those accused under it in confirmation with the First Amendment. Our statute permits the qualified privilege to exist regardless of whether the publication was true or false when it is a comment made in the reasonable belief of its truth upon the conduct of a person in respect to public affairs, and in such case actual malice must be proved by the state. Our criminal statutory requirements for proving actual malice are in accord with those set out in the New York Times case for civil libel. Our statute is clearly constitutional when measured by the standards set out in the New York Times case to satisfy the First Amendment. And then it goes on, of course, arguendo, and says this: in our opinion, our statute is not repugnant, and this is the same statute that he's prosecuted here, is not repugnant to the First Amendment simply because it recognizes that the public have an interest in the maintenance of the public character of public men. Public affairs could not be conducted by men of honor with a view to the welfare of the country if attacks upon them could be made at will, destructive of their honor and character, and made wholly without foundation. Our statute sufficiently protects those honestly criticizing their public officials as to their official conduct to satisfy the First Amendment, but it properly forbids unjustified, malicious attacks upon them. And may I remind this court
General
that the defendant...
General Gremillion, your statute does apply, doesn't it? Even if the expression or publication is true, if actual malice can be proved.
Oh, yes, absolutely. In other words, our Supreme Court has now held in accordance with your ruling that in the prosecution of a public official for defamation, actual malice has to be proved.
Yes, but Mr. Gremillion, the Times case defined actual malice as a knowingly false statement or a statement in fact false made in reckless disregard of the truth.
And that is...
Now,
that's true.
May I ask the question,
yes,
please? Under your statute, as I understand it, if the statement is in fact true, there may be a criminal prosecution. If ill will toward the person defamed.
That's what I said, Your Honor.
It's proof. I know, but isn't that inconsistent with the Times?
No, it's not. It's just a question of fact now. It's a question of fact as to whether actual malice was proven by the state.
Well,
and in this case, in response to a bill of particulars,
let me ask you the question.
All right, I'm sorry, Your Honor.
If the Times case rests, as I think it does, on the falsity, basically, of the statement said to be defamatory, that is the test. Even a false statement is not the subject of a civil libel act unless the false statement was made knowing it was false or in reckless disregard whether it was true or not. But under your statute, as I understand it, even a statement in fact true may be prosecuted if the one making the statement makes it with ill will toward the person defamed. Isn't that so?
Yes, and in that instance, our court, that's the reason why I read you the Cox decision, our court has adopted and supported the New York Times view that now, regardless of civil or criminal prosecutions, that when you're speaking of a public official, actual malice is an essential ingredient of the crime and must be proven. Actual malice, that it was made with ill will, that it was made to expose the individual to hatred, contempt, and ridicule.
That was made no element of the New York Times.
No, absolutely not. And that's why this case is distinguished from the Sullivan case or the New York Times case.
In this case, we don't have an issue, because, as you say...
The factual situation here is entirely different from the New York Times case. These individuals, public officials, as you recall, in the Sullivan case, weren't even mentioned by name. And in the Sullivan case, one of the officials of the New York Times had stated that he had looked into it and he felt that he had every reason to believe that it was true. But we've got a different factual situation here in the Garrison case.
Yeah, but the same rule applies. You say that they must prove actual malice, as defined by the New York Times.
Right, that's correct.
Do you know of any evidence in this record that, to the effect that the defendant knew or that there was reckless disregard for the truth of the statements that he made, other than the judge's statement that, of course, no one could make statements about these men, these honorable men, without having actual malice or without having reckless disregard for the truth?
The record is, of course, the record speaks for itself, Your Honor, but the record has and shows actual malice in that he knew or had reason to believe, and we proved that about the vacations, we proved about the vice, we put the chief of police, the New Orleans police on the force to show that he had these 12 men. We put the judges on to show the vouchers. We actually put the vouchers in.
You just proved the statements were false. That's all you're talking. You proved the statements were false.
We proved the statements were false, and we proved that they were made with malice. Yes, we actually told him that we were going to prove malice in law and in fact, and the district court found that in its well-worded opinion.
Where's the evidence in the record on malice? Other than, I agree that there's some evidence in there as to whether or not the two statements were were false. What about malice?
Malice in the sense, Mr. Attorney General, of that he knew these statements, which were proved in fact to be false, were false when he made them, or that he made them in reckless disregard of whether they were true or false. Where's that evidence?
Page 613 of Volume 2, the findings of the lower court on the question. Yes, it's about 10 pages devoting to malice.
What page did you say?
613, starting at 613. It starts really at 610 in the opinion of February the 6th, and it goes on through and is devoted, about 10 pages is devoted to it.
This is the opinion, yeah.
This is the findings of the trial. This is the findings of the trial court. Now, you see, in Louisiana, you only can appeal on exceptions which are taken to the various rulings of the court. And the lower court opinion, of course, deals with it, but the details of actual malice are found in this opinion by Justice Ponder. Honestly, it's too long. I'll be glad to read it for you, but
no. I was really wanting. I'm familiar with the opinion. I was just wondering about the evidence in the record. But
now let me say this: that the state put on 23 witnesses,
record will speak for itself.
And the defendant called 22. And the defendant never took the stand, which is not to be held against him, and I'm not urging that now. And he didn't call a single one of his witnesses. And every fact that the state of Louisiana proved was absolutely uncontradicted and is there without any contradiction whatsoever. Yes, in other words, it says that you have a qualified privilege where the publication or expression is a comment made in the reasonable belief of its truth. And then upon A, the conduct of a person in respect to public affairs. So, yes, I agree with that. I definitely agree with you. And I call to your attention the fact that the state of Louisiana in this case advised the defendant they were going to prove malice both in law and fact, and actually did so. And now our Supreme Court has come along and answered the very thing that you justices are speaking about now. And I'm going to have a copy of this, sufficient copies of this made and send it to you, and I'll be very happy to do it. Now, I only have this one copy. I don't need it. I'll be glad. I have some notes on here which oh, yes. Will this relieve me of the necessity of sending further copies in? I will be very happy to do so, Your Honor. I certainly will be very happy to do so. I suppose that that's about all I can say in this particular case now, except to...
How about the jury trial issue, Attorney General?
In Green versus the United States, which is cited at page 147 of the opinion of the Supreme Court, this court held that criminal contempt cases are not subject to jury trial as a matter of constitutional right. A misdemeanor in our law is defined as an offense, the punishment of which is necessarily a fine or imprisonment in the parish jail or both. And in this particular case, I think the maximum fine is $3,000 or 1 year. And incidentally, Colonel Deutsch, in the Cox case, they were only sentenced to 1 year in the event they failed to pay the fine, not 2. Now, we, of course, in State versus Haddad, which is cited in the opinion of the Supreme Court, went thoroughly into that question. And our Supreme Court has found that as long as an individual charged with a misdemeanor has the proper guarantees, such as the filing of a bill of information, the right of cross-examination, the right of counsel properly and timely and so forth, that there is no violation of his constitutional rights, and that misdemeanors can constitutionally be tried before judges. No, we weren't talking about, the court wasn't talking about libel, they were talking about a criminal statute. Well, my answer to that, of course, is that there is no violation of an individual's rights without a trial before a judge, because the rights that he's guaranteed under the First and 14th Amendment can be just as thoroughly tried before a judge, in fact better than it can before a jury. And that's what this court held in the Jacobellis, I don't know how you pronounce that, and this quantity of books.
But Mr. Attorney General, I think I'm correct that even before our Constitution, England had introduced the jury trial requirement as a safeguard against abuse of criminal libel. Does that have any relevance for us in interpreting the First Amendment?
No, it does not. Absolutely not, because our codal system was drawn up, of course, our Code of Criminal Procedure was drawn up by...
I asked as to the First Amendment. Does that have any significance for us?
No, I do not, and I'm trying to answer, Your Honor, because there is no case in the Louisiana jurisprudence or the federal jurisprudence from this court that says that a jury trial is required as a result of the privileges guaranteed by the First Amendment. Now, if this court says so, it will be something absolutely de novo.
Well, my question is, isn't that something we're going to have to decide in this very case? Maybe the first time it's appeared here.
Well, it may be. But I don't think that it's necessary. I don't think it is necessary to sustain this conviction. And I don't think that after you read this particular record, you will find out that this accused's rights were violated in any way. Well, but I do agree with you that there's a lot of things that you could go into in this case which are entirely new.
Well, if the Constitution entitled him to a jury trial, he didn't get it, although he insisted on it.
Oh, he did not get a jury trial, that's true. And if you do that, well, then we'll probably have to go back and try him again. But there are a lot of things in this case that you could go into as a matter of de novo. I mean, for instance, with the 14th Amendment, there's several things that you could go into. But that has never yet arisen in any of the cases that have been decided either by this court or by our Louisiana Supreme Court. Now, if you do that, I will say this, that you're going to impose a tremendous burden upon the states, because then every misdemeanor, every traffic ticket, every simple battery case, every case will then have to be tried by a jury. And Louisiana is one of those particular states that has consistently held and has been tested in the courts that an individual being tried by a judge before a judge alone for a misdemeanor, that all of that accused rights are thoroughly protected as a result of that particular trial procedure. And I say this again, that if you do that, you're going to force us to rewrite our entire Constitution on that particular point.
Statute that has to be shown. Quite obvious that this gentleman didn't approve of these judges. He didn't think they were good judges, and he didn't think that they ought to hold their jobs and so forth. Is that enough?
Or you have to prove that what he said was a result of ill will and a result of malice, and that it was done deliberately.
I mean, personal ill will to him?
Oh, yes. And again, Your Honor, it comes to the reading of the entire record, because when the man says that the only reason that they're doing this is because they're influenced by racketeers. Now, when we say the influenced by racketeers, that means that he's influenced necessarily by a man of ill repute, and it indicates, of course, that he could have taken a bribe. And then to further show his state of mind, we never did have the opportunity to probe him or his state of mind because he didn't take the stand. But then immediately after the charges were filed, he makes another statement in which he says it's a racket. He says if I had to do it over again, I'd do it. I'd have no regrets. I'd continue to do the same thing. He continues to call them sacred cows. He continues to malign them. He continues to say that it's nothing but racketeering questions and influence, that there's no other question involved, that they're an association of armed robbers. And just a few days before his trial, he again repeated the fact that these judges were influenced by racketeers. So when you assume, and all of that was introduced, of course, to show the question of malice, which was the only way that we could prove it. So when you lump all that together, I don't see how any court could find, and I think the district court quite properly found, that these statements were malicious because we proved that they were not true. We put the judges on the stand and asked them, did you read this statement of November 2nd? I did. Is it true? No. Every one of them said the same thing. And we asked them, have you been subjected to ridicule? Yes. We couldn't, of course, say what that was because that would have been hearsay as between the individual that criticized them and this particular defendant. But we did prove that. We proved that in every instance. We proved that the statement was false in its entirety and that it was made with malice.
I understood you to say, though, that under your statute, even if it was true and done with malice, and you defined malice as ill will, that he would still be guilty under your statute. Would you mind repeating that, Your Honor? I understood you to say that under your statute, even if what he said was true, if he said it with malice, namely with ill will toward these judges, that it was punishable.
No, I don't think I said that because...
Well, I thought your statute says that.
The second paragraph of Section 48, and you've said yes to that question at least 6 times. Second paragraph of Section 48.
Yes, I agree with that, yes. Definitely.
Now let me ask, let me put a hypothetical question to you then. Suppose a judge approached a litigant and told him that for a certain amount of money he would decide a case in his favor.
Yes.
And the litigant became outraged and had thorough ill will toward the judge from that time on and exposed him to the public and stated that as a fact, that the judge had solicited a bribe from him in order to decide a case in his favor. He did it intentionally for the purpose of discrediting the judge in the eyes of the public. Under your statute, would he be liable?
Oh, yes.
He would?
Yes. If it was made with ill will and malice, yes. And in addition to that, now wait a minute. You mean if the individual was prosecuted for defamation?
Yes.
No, I don't think he could be convicted under that set of circumstances. I do not. I absolutely do not, because he would have a complete defense. He would have a defense of the truth.
Your statute says whether it's true or false.
That's correct. To expose any person to hatred, contempt, or ridicule, or to defy him on the benefit of public confidence or social intercourse. Where's Section 48? I don't know.
You'll find it, among other places, on page 3 of the appellant's brief. The second paragraph is the one to which reference has been made. Well, here's what it says. Where such a publication or expression is true, actual malice must be proved in order to convict the offender.
Yes, the statute does say that, Your Honor, but we've never had a case like that to happen before, and I believe that if the man could actually prove that he had solicited a bribe, I don't believe that they could convict him of defamation, and in addition to that, I think the judge would be subject to disbarment proceedings.
General, I suppose you say that as applied to this case,
But this case
involves falsity.
What's that?
The fight for this case involves falsity proved by the record.
And I've come in that, Mr. Chief Justice Warren, your hypothetical situation, of course, I've got to answer that way because that's where it is. But that doesn't apply to this particular case, because this particular case was predicated upon the fact that the statements that this defendant made were false, and they were known to be false and were proven to be false.
I understand that. I was just testing out the extent of the limit of your statute, was all.
That's all I have.
You may, you have a few moments. Would you take them now?
I really just say one thing in connection with the matter of the jury trial. Fox's Libel Act in England was 1792, and undoubtedly the discussion which formulated itself into Fox's Libel Act was part of what into the First Amendment. At least that is my honest conviction.
That argument's been mentioned a number of years before.
Oh, many years. That had been going on since before William Penn was tried, and so on. Yes, sir. That was a accumulation which is just as much a part of the history of the First Amendment as it is of Fox's Libel Act itself.
Number 400, Jim Garrison, appellant, versus Louisiana. Mr. Deutsch.
Chief Justice, may it please the court. Appellant is the district or prosecuting attorney for the Parish of Orleans, which is coterminous with the city of New Orleans, Louisiana. He was inducted into office about 2 years ago, and following that induction, set himself 2 goals. First was an intensive attack on the back.
You say he set himself 2 goals?
Yes.
Yeah.
The first was an intensive attack on a backlog of criminal cases awaiting disposition, and the second was a campaign against commercialized vice in New Orleans, Bourbon Street section. Under Louisiana law, all fines and forfeitures in criminal cases go into a special fund under the control of the district attorney for the payment of the expenses of his office and certain expenses of the criminal courts, and he may make expenditures from that fund under the appropriate statute on the approval of a judge of the court. Such funds had always been used to pay for investigations made by the district attorney on approval by a single judge, and that applied to his predecessors in office, and it applied to him during the first few months of his incumbents.
Is this the only source of funds to enable the district attorney to make investigations?
There is a provision under which he is supplied with police officers by the city of New Orleans. They are not funds which he uses for that purpose.
They're personnel paid by the
personnel paid by the city is made available to him. Aside from that, actually, that is not a fund given him for that purpose. This is the only fund, as such.
His own salary doesn't depend upon
No.
the fund, does it?
No, his salary is a state salary paid. This is for what we might call incidental expenses, sending people to, in extradition matters to other states, and paying for furnishings of the office and for the offices of the judges, and so on and so on. A short time later, however, the judges met en banc and adopted a rule. There are 8 of these judges, adopted a rule under which such expenditures would not be approved except on the concurrence of 5 of the 8 judges. And not long thereafter, they discontinued altogether the approval of expenditures for vice investigation.
This was done after he was elected and took office.
This was some months, 5 or 6 months after he took office.
How long a term is his term?
4 years, I think.
And he was first elected in 1962.
Well, he took office, I think, in May 62. We have a kind of an irregular system of the elections. We have primarily primaries.
Yes, sir. But so he's now serving his first
Oh, he
term.
is now serving.
He was then and is now serving his first elective term.
Correct. A few days later, after this fund was cut off, one of the recently retired judges of that court made a statement to the press charging appellant with responsibility for the backlog of these untried cases. He had been in office, as I say, a few months at that time. On the following day, the newspaper reporters came to him and asked if he had any comment to make about this statement. And it was in response to that request that he made the statement which is the subject of this litigation.
Did I understand you to say that that judge was retired at the time?
Had recently retired, just recently retired. He was actually in office when appellant took office as district attorney. He retired between that time and the time of these incidents. Now, appellant said, in answer to this statement by this judge, in substance, that it was the judges who were responsible for the backlog of untried criminal cases, that they had been taking excessive vacations, that they were endeavoring to block his vice investigations, and that their attitude, and now I quote, may it please the court, raises interesting questions about the racketeer influences on our 8 vacation-minded judges. In the record? It's right in the very beginning.
Page 7 and 8 of your brief, isn't it?
Yes, but that's not in full in our brief.
120 and 24 is that.
If you will look at page 27 of the transcript, it is quoted in full, 27 et sec. Goes through to page 32. At that point given in the text of the indictment, or rather the bill of information which was filed against. Now, on petition, formal petition of the 8 criminal court judges, the Attorney General of Louisiana filed a bill of information charging appellant with criminal defamation under the Louisiana Defamation Statute. And the Supreme Court of Louisiana appointed a judge from another district to try the case. Trial by jury was denied under the Louisiana constitutional provision to the effect that a judge alone may try misdemeanor cases.
Is there a timely demand for a jury trial?
Oh, yes. Formal motion on page 38 of the transcript. And formally denied, and that point was formally taken up on appeal and so on, passed on. Under this particular statute, $3,000 or 1 year in jail or both. Now, let me say, there are apparently some mistakes, one in the record somewhere and one in the Attorney General's brief, leaving out the word or both. Actually, it does show in the original part of the Attorney General's brief, but later on it is quoted again, and apparently in error the words or both are left out. I think they're extremely significant in light of the recent Barnett decision. But it is also left out in the opinion of the Supreme Court, unaccountably. Those 2 words, or both.
And what's the significance of that?
Pardon?
I didn't understand you say, what's the significance of that?
Well, you talk about petty offenses may be heard without a jury. Here you have a maximum penalty of $3,000 or 1 year in jail or both. I think.
What actually was the penalty?
You mean the sentence in this case? was a fine of $1,000 or, in default of payment, 4 months in prison.
4 months.
Now, as I say, trial by jury was denied under this constitutional provision, and
was exception to that denial taken on federal constitutional grounds?
This was passed on by the Supreme Court again on appeal
On
expressly. Pardon?
On federal constitutional grounds?
Oh, yeah. There is a little, but there's no question raised about it. The Sixth Amendment was mentioned. And then it says, the motion says, the 6th and 14th are mentioned in that motion, but it also goes on to say in the alternative under the freedom of speech provisions also, without saying in so many words the 1st and 14th.
And of course, this is not really a criminal contempt, is it?
This is not a contempt case at all. This is a criminal prosecution for defamation.
Under a defamation statute.
Under a specific state defamation statute. Or a misdemeanor. I assume you're not making that distinction. It is a prosecution, and it is a prosecution without a jury. Of course, that sort of advances my point a little, but I'll get to it again if I may. Also, his pleas under the 1st and 14th Amendment that this statute so applied violated the 1st and 14th Amendments with regard to his right of free speech was also specifically overruled, and again it was passed on by the Supreme Court on appeal, and so on. The judge found appellant guilty, sentenced him to pay this fine of $1,000 or 4 months in jail, stating that he did so under the mitigating circumstances of the case, and that he would be less than frank, and I'm quoting, if he did not say that the defamatory statement might not have been issued without some provocation. Of course, that goes into this question of malice. The Supreme Court affirmed, it held in substance that there was no violation of the 1st and 14th Amendments on free speech, that it found no provisions in the Constitution of the United States requiring a trial by jury under such circumstances, and because Louisiana treats defamation and contempt as separate offenses, it is unnecessary for us to consider the issues behind the phrase clear and present danger under the opinions of this court, which deal with which have dealt with the offense of contempt.
Now, malice is an ingredient of the offense, is it? I know it says malicious publication, but what's that mean?
That raises interesting questions of statutory construction and really is not directly pertinent here because the state took it upon itself to prove that there was malice without raising the point whether it had to do so or not. And there was a finding.
Well, are you making any attack upon the sufficiency of the evidence of malice?
I am, insofar as that word was given a definition by this court recently in the New York Times case.
What does that mean?
Mean what I have just said?
What do you mean by that?
This court held in the New York Times case that actual malice was a deliberate misstatement of fact or a reckless disregard as to its falsity. There is no such finding we submit in this record. There is a finding in words of malice, and I'll come to that if I may.
And you say there's no evidence to support a finding
of malice under that definition. Now, let me have this. I think I can clarify that immediately by reading a short paragraph on page 633 of the transcript from the opinion of the trial court, at the first full paragraph at the top of the page. After making the finding of malice on the preceding page, the judge said, however, were it conceded for the purposes of argument that he did have a reasonable belief as to the truth of the statement, and his statement was entitled to be considered a qualified privilege, I am of the opinion that the state has proved actual malice in its many definitions, etc. In other words, even if he had, says he, a reasonable belief in the truth of what he was saying, I still find he was actuated by malice. That could not be the malice which this court recently defined. Well, under Louisiana law, as I understand it, I trust you'll forgive me, this is the first criminal case with which I've ever had any connection, but as I understand it, any sentence of more than 1 year is not served in the parish prison. And I think that would straighten that out. If I'm wrong about that, I'd be happy to stand correct. That's my understanding. But there is no question that a misdemeanor is one that goes up to 1 year. Now, we do submit, may it please the court, that the validity...
Forgive me.
Surely.
I'd just like to go back, if I may, for 1 second to this malice question. Is it your suggestion that the way the court phrased that, were it conceded for the purposes of argument that he did have a reasonable belief, that the court is suggesting there that he did, in fact, or that there's any finding that he did, in fact? If
you will read... Mr. Justice Brennan, on the preceding page, toward the bottom, the long paragraph
he
at
says
the
he
bottom.
could not have reasonably had any honest or reasonable belief.
He puts it, of course, in the form of an inference.
Yeah.
He says, I cannot understand that he could have any other. He doesn't make it a finding of fact.
I see, yeah.
And then he goes on, but even if so, he's actuated by malice anyway, even if he believed it was true.
Well,
so he's not talking about your kind of malice.
Well, what I wanted to get to was this. If we should agree with you that at least this suggests an ingredient which is contrary to the test we stated in the Times case, would that entitle you to a reversal?
I think that alone would, but there are many other grounds.
But on this ground alone, you don't think it would?
Well, you see, in the Times case, you didn't make a finding with regard to a criminal case at all. You were talking about the right to recover civil damage.
No, I'm only assuming from what you suggested that we should agree with you that the malice test is that for this statute as it was in the Times case.
Then,
on that assumption, what I'm trying to get to is whether you think there's sufficient departure from the Times test of malice that you'd be entitled on that ground alone, assuming the Times test applies, to a reversal.
I stand on that, yes.
You do think so?
Yes.
Thank you.
Of course, as I was just starting to say, perhaps indirectly in that connection, that we do take the position that the application of a state criminal libel statute, especially when employed as a sedition law with regard to criticism of public officials, simply can't be reconciled at all with the principles of the First Amendment passing through the 14th with regard to a state statute. That's, there seems to have been considerable controversy on that subject in this court. I don't have to go all the way with the proponents of that principle, whatever my own views are, but in this particular case, you've got a general criminal libel statute being applied as a sedition. Now, of course...
You're limiting this now. Is this argument limited to a public official?
That's as far as I have to go.
That's right. But is your argument based that this is a sedition law?
That this is being applied as a sedition.
Because it involves...
Criticism of public officials. That's right.
But in their official capacity?
Well, of course, the argument is made on the other side that it is not.
What does your brief say about that?
What does our brief say?
Yeah, whether it was in there in his official capacity or not.
Well, I don't think there is the slightest question that when you say a judge took a bribe, if that's what you say, for instance, that's not involved in this case, you are certainly talking about the judge in his official capacity, whatever reflections you may be casting on his personal character.
There's no suggestion in this case, or in any of the allegations, that he took a bribe in connection with any suit.
Oh, there's no bribe question here at all. I'm using that for illustration.
Right. The worst that was said about him was he was a racketeer.
No, they didn't even say that. He said, this raises interesting questions as to whether our vacation-minded judges are subject to racketeering influences or something of that. He did not say it about each and every one, unless you want to read this thing with great care, an oral statement made to reporters, who said as to whether our 8 vacation-minded judges are subject to racketeering influences.
What do you say about the constitutional argument that made by many of it? Says the courts just can't survive. They'll be destroyed, lose their existence, unless they can sentence people to contempt who criticize them.
Well, I think perhaps I could best state it by stating, sir, that I stand with you and your views on that subject as heretofore expressed. I take it I don't need to elaborate on that statement. I should be very happy to do so. I have read every word written on the subject. Now, I do say that the opinion of the Supreme Court of Louisiana was rendered, of course, before the New York Times case. The Supreme Court of Louisiana relied on the statement in the Beauharnais and prior cases which said libel is not covered by the First Amendment. You all straightened that out to my satisfaction in the New York Times case, stating that your expressions in the Beauharnais and other cases to the effect that the Constitution does not protect libelous publications do not foreclose inquiry into cases which might involve the use of libel laws to impose sanctions upon expressions critical of the official conduct of public officials. And incidentally, Mr. Justice Black, you have in our brief a statement by Mr. Justice Brewer which takes that question about destruction of courts by criticism of judges and applies it to the Supreme Court of the United States and says it might be used as current fiction, perhaps, because no such thing could possibly exist.
I remember referring to that more than 27 years ago.
I remember that reference, too. Now, I do call your attention, if I may, to a couple of matters which you have not had occasion, at least, to put into your briefs, into your opinions, and which, as far as I know, have not been in briefs before this court in analogous cases. For instance, that Madison, in the Virginia resolutions on the Sedition Act of 1798, that it would seem a mockery to say that no law should be passed preventing publications from being made, but that laws might be passed for punishing them in case they should be made. Gets back to this question of previous restraint not being the full scope of the First Amendment. And Gouverneur Morris, with regard to the Zenger acquittal, said that the germ of American freedom, the morning star of that liberty which subsequently revolutionized America. And Dean Pound said the same thing. He cited in an article a case of a chap in England who had been convicted for saying that a certain justice of the peace was, quote, a buffle-headed fellow. And Dean Pound says it was that sort of thing that led the colonies, as soon as they could make a frame of government for themselves, to put these provisions with reference to the liberty of the press in their Bill of Rights, a criticism of a judge, or justice of the peace in that case. Now then came the Sedition Act, the Federalist, ruthless enforcement of its provisions, and then this is something else, so far as I know, that has never been mentioned in that connection. A resolution was introduced in the House of Representatives to repeal the second section of the Sedition Act. It was approved in the House. It was passed in the House by a vote of 50 to 48 on the lone Federalist vote of John Marshall, who very nearly wrecked his political career by that statement because he went directly against his party. He was the only Federalist in the Congress which had a majority of Federalists which went along with the repeal of the sedition law. Now, in 1940, Attorney General Robert H. Jackson refused to institute a prosecution for criminal libel of a public official under the District of Columbia's Criminal Libel Act, stating that that would constitute embarrassment not consistent with our support of the freedom of the press, and it is therefore Department of Justice policy that we do not institute that kind of action. Actually, on statistics which we have cited in our brief, it is shown that the larger number of criminal libel actions recently instituted throughout the United States have been for libel of public officials, that is, as sedition acts. After all, this court has held uniformly now in a number of leading cases that out-of-court criticism of judges may not be punished as contempt without trial by jury and in the absence of a clear and present danger of interference with the administration of justice. We submit that you cannot change that rule in a criminal libel prosecution without a jury simply by calling it, labeling it criminal libel or sedition instead of contempt of court. We submit there is no real difference there. Now, the question of malice is really the only other one, whether this court intends to substitute that rule for the clear and present danger rule, which I'm sure it did not in the New York Times case, and or whether perhaps it means to add that on to the requirements amongst the clear and present danger rule. We submit that in any event there has not been a finding of malice, as I stated a few moments ago, within the meaning of that expression as used in the New York Times case, that the prosecution in the case at bar violated the First and 14th Amendments, and that the opinion of the Supreme Court of Louisiana should be reversed.
Well, now, the trial judge did say, he said, it is inconceivable to me that the defendant could have had a reasonable belief, which could be defined as an honest belief, that not one but all 8 of these judges of the criminal district court were guilty of what he charged them with in the defamatory statement. Now, you say he didn't characterize that as a finding, but he said that certainly is a very clear-cut conclusion, that the defendant
no question he made that
was not telling the truth and knew that he was not telling the truth. That's the finding, isn't it?
He said, I cannot escape that inference or that conclusion. Yes. He did not make it a specific finding.
Well, he said, I cannot escape the conclusion.
I cannot escape that conclusion.
And then he says, I can only conclude.
Well,
he made no findings or
that's
conclusions.
correct on that.
Well, now, in view of that finding by the trial court, which I gather you don't specifically take issue with, why isn't that
I do
malice?
take issue with it. We took issue
You
with
say
it
it's
on
true?
the facts. Oh, yes.
And you
And
still
we
say
say
so
that
here?
you all, under your own decisions, will examine the findings of fact, and we trace them in the brief.
Yeah.
See, in a controversy of this sort, started, let us say, for immediate purposes. There was stuff preceding all this that I have mentioned. There was some more afterwards. If you look, for instance, at note 3 on page 6 of the supplemental brief, our supplemental brief, you'll find a speech which he made, the appellant made a couple of months later, talking about these excess vacations of these district judges and so on, that he felt himself bound to tell the people of New Orleans the truth. The only way he could get these sacred cows back to work was by informing the public as to what they were doing. Now, a public official under Wood versus Georgia and so on has a duty to say those things, and in our opinion can't be charged with malice for saying it.
Well, I'm just going to the trial court's finding that the defendant knew what he said, that what the defendant said was false, and that the defendant knew it was false.
I don't treat that as a finding, sir, but that we begin to get into semantics there. I think it is simply an inference on his part, and not a formal finding, but that even if it is, we find fault with it.
If it is a finding, on what is it based? Is it based on?
Oh, there's evidence. There's hundreds of pages of evidence here. He bases it...
It's a common, ordinary thing for a man to think that someone else who violently disagrees with the view that he violently holds either has to be dishonest or foolish. How are you going to get down into the knowledge of what a man absolutely knew about everybody? John Stewart. That's the reason I asked. What are the facts on which he based that statement?
Well, the fact that he made similar statements on other occasions, which showed that he was repeating, and that could be engendered only by malice. That's why I call it a conclusion rather than a finding.
As far as it's truthful, does he say that because the man said it and kept repeating it, that it's bound to be a falsehood?
He made one other. I'm not going to try to say that I'm going to give you now all the evidence on which that was based, because there are hundreds of pages of evidence. But for instance, he said he couldn't conceivably have believed that all of these judges were subject to racketeering influences, and he made no exceptions when he made his statement. He takes that, for instance, as an indicium of malice.
Was he taking judicial knowledge there? Did he have some evidence on which to base that?
Well, I assume he knew the judges, but I assume also that he tried his case on the record. I have no fault to find with his going outside the record for that purpose. I call your attention in the New York Times case to footnote, I'm sorry, I don't have an official copy here, but it's footnote 13, citing John Stuart Mill on liberty, stating that there just has to be misstatement from time to time in the course of controversy in public life, and that's not, in effect, evidence of malice, because it says very fine people do that from time to time. Now, if there is any misstatement of fact here, in my humble opinion, it could be found only by construing these words in a certain way in which, in my opinion, they were not meant, and I just don't believe they were meant.
Sounds like it's probably down in New Orleans that people never exaggerate in political fights among themselves.
May I quote that to the Chamber of Commerce?
Attorney General Gremillion.
Mr. Chief Justice, members of the court, I think that the law in this case is pretty well expressed in the Times Sullivan decision, which states that where defamatory remarks concern a public official in his official conduct, that actual malice must be shown to sustain a conviction for recovery in a civil suit, and likewise to sustain a judgment of guilty as charged in a criminal statute. I have no argument with that. And I certainly appreciate counsel's marvelous opportunity and presentation to try to bring this case under the Times rule. But as you said in the Times decision, that it was your duty to, it is not limited to the elaboration of constitutional principles. We must also, in proper cases, review the evidence to make sure that these principles have been constitutionally applied. I'm very confident that this court will do that. And I know that when you do that, that you will find here the district attorney making malicious statements that attack the personal reputation of these judges, which subjected them to hatred, ridicule, and contempt, and which destroyed their public confidence. Now that is the charge that the state made. Let me review our defamation statutes. And I ask you to bear in mind that this is not a contempt proceeding. Contempt is defined as an entirely different matter in the state of Louisiana. Contempt can be constructive in the presence of the court, or it can be outside of the presence of the court, such as a newspaper publishing an editorial about the conduct of the court. And I might say that Louisiana recognizes the clear and present danger, because in the case of Graham versus Jones, which is cited in our supplemental brief, the Supreme Court of Louisiana said that this editorial of the Times-Picayune would certainly have no effect on the decision of these judges, and dismissed the contempt citation of the Times-Picayune. But we have no clear and present danger involved in this particular matter, because there was no question about the obstruction of justice. There was no question about the defamatory statement going to the personal reputation of these judges. And what the defendant did here, he used...
Mr. Gremillion, that these statements really are not an attack upon the official conduct of the...
We contend that they go to the personal reputation of these judges, and our bill of information charged that he willfully and maliciously made it, and that it subjected them to hatred, contempt, and ridicule, and destroyed their public confidence.
You're saying this case should not be viewed as criticism of a public official?
Absolutely.
I mean, it should or shouldn't?
It should not be considered. These men happen to be judges, and he defamed them in their personal category.
Well, Mr. Attorney General, is it conceivable that he'd have said these things if they were not in office?
I don't understand your question, sir.
Would he have made these statements if these men were not in office as judges?
Oh, I absolutely not. He would have had no occasion to. But what I'm getting at is this, that he filed, the defendant filed a motion for a bill of particulars, which we answered. And we charged in that bill of particulars, we answered in the bill of particulars, that we were going to use the statement in its entirety. And we were going to depend upon the statement of November the 2nd in its entirety. And that he asked also whether these statements were made as maliciously. And we answered him that we would prove that the statements were malicious both in law and in fact. And we put on 22 witnesses to prove that, number one, the statement that he made was entirely false, and number two, that it was made with actual malice. And the record is complete in that particular respect. Now let me say this.
General, may I ask you,
yes, sir.
what particular statement or statements are in his press release which disassociate these justices from their official duties? In other words, what did he say that can be said to be only personal against these judges and not what has to do with their official conduct?
Well, you have to take the statement in its entirety and look at it as one. And in there, he said that all of these things about the backlog of cases, which I'd like to talk about in a minute, and about the crowded condition of the jail, those judges have nothing to do with that, absolutely nothing to do with that. The criminal sheriff is in charge of the jail. The district attorney in Louisiana has complete charge of the docket. He determines who comes to trial, when he comes to trial, and how he will prosecute it. All of those statements in here are absolutely false, and we prove them as false. And then here's where he hits at their character. He says, all of this, for instance, he says, again, the message is clear. Don't rock the boat, son. You're not supposed to investigate anything. Well, the judges never sent him any such statement like that. They never told him that. They all took the stand and said that this statement was false in its entirety. Now, the statements about official conduct was conduct with which these judges had nothing to do with. And then, after making all these statements, he comes up with this. This raises interesting questions about the racketeer influences on our 8 vacation-minded judges. Now, in the first place, those judges were conducting their court in accordance with the law. It never was proved that they took vacations. They didn't take any vacations at all. We've got to remember that courts certainly require a lot more time off the bench than they do on the bench.
You just said they were vacation-minded.
That's right. He said they were
vacation-minded.
But of course, if they were guilty of taking excessive vacations, contrary to the law, they could be indicted and prosecuted for malfeasance. But instead, he had a lot of legal remedies. He could have held an open hearing if he had evidence that these judges were racketeers or they were influenced by racketeers. Certainly when you say you're influenced by a racketeer, you're stating the ordinary meaning of the word to the general public. And when you say that I'm influenced by a racketeer or you're influenced by a racketeer, that means that some crook is either paying you off or bribing you to influence you in your decision. And it can have no other meaning.
But that's a charge of relating to official conduct, seems to me.
All right. Okay. I don't think so, Your Honor. I don't think that relates to official conduct. Because if that were true, they had no business serving as judges. And that was the reason why I filed this bill of information against Mr. Garrison, because if he could prove that those men were influenced by racketeers, and that they were being influenced by racketeers, they had no business serving on that bench, and they should be indicted and tried and removed. He had a remedy. He could have gone to the Supreme Court and asked the judicial administrator of the Supreme Court of Louisiana to investigate it. He could have brought it before the grand jury himself if he had that particular evidence. And of course, as the trial judge says, I can't find out what's in Mr. Garrison's mind. Incidentally, he didn't take the stand in this case. He subpoenaed some 22 witnesses and didn't put a one on. We put on 23 witnesses to prove that he made this statement with actual malice and that it damaged these persons individually. And after we finished our case, he rested. So the facts in this case are absolutely uncontroverted. There's no doubt about it. There's no doubt about the fact that the judge, when he made the statement, it is inconceivable to me that he knew these statements were false when he made them. Because if he didn't find that under his oath of office, he's required to find the man not guilty. So that's one of the ingredients of the offense. False and malicious statement. Because of the fact that we have proved that the statement was made with actual malice to injure these people. Well, we go there to the gray matter that you talked about. Now, this could be but you see, he was using a qualified privilege as a vehicle to vindicate himself against these persons individually. And several of our historians have made statements concerning that. We have one in our original brief. I don't remember who made it, but he said that the First Amendment certainly didn't allow an individual in the right of freedom of speech to abuse that particular liberty. And Louisiana law, I submit, is in complete accord with the rationale of the Sullivan or the Times case, however you want to refer to it.
You think there's evidence in this case to show that this fellow, that he actually knew the information was false?
Oh, yes, evidence supports that. Let me briefly run down this.
Not false, but that he knew it.
Oh, yes, absolutely. Because he certainly knows the criminal statutes, because he's a district attorney and he's a lawyer. 1557 provides that he's in charge of the docket. He knew that that was his responsibility to bring those cases to the trial, not the judges. And if a prisoner was in jail and wanted to get a quick trial, and the DA didn't want to bring him to trial, he could file a motion with the court, and the court would then fix a trial date. But you see, the reason I say it's within the rationale of the Sullivan and Times case is this particular reason. A quality that I'm quoting from our defamation statute. Our defamation statute says that defamation is the malicious publication or expression in any manner to anyone other than the party defamed, to expose persons to hatred, contempt, or ridicule, or to deprive him of the benefit of public confidence or social intercourse. It's punishable by a fine of $3,000, not more than 1 year in jail. Now, 49, revised statutes 1449 provides this: a qualified privilege exists, and actual malice must be proved, regardless of whether the publication is true or false, in the following situations: the conduct of a person in respect to public affairs. And then the next article gives an absolute privilege to a legislator and a judge and a statement of a witness stand and so forth. And this is the same statute that you mentioned in the Times case that was enacted in the 1908 Coleman case, where the state attorney general was running for office. And there you found that the law was appropriately set forth in the Kansas case, and noted that there were some 20-some-odd states that had similar laws, and Louisiana, I submit, is one that has similar laws. Now,
are your judges elected down there?
Yes, sir. They're elected for, I think, 8 years, if I'm not mistaken, yes. You see, the Parish of Orleans has a home rule charter, and the district attorney is elected at the same time the mayor and the councilman are. They go in for a period of 4 years. Other district attorneys in the state are 6 years. But the judges, they're 12 years in the Parish of Orleans. And in other districts in the state of Louisiana, of course, they are 6 years.
Do they alternate, or are they all?
They preside over sections. They have A through H, and each one has that particular section. And the judge with the longest service, which is Judge Platt, who's been on the bench 44 years out of his 50 years of practice with a long and honorable career. He was one of the men that was defamed in this case. The one with the longest service is the chief judge. But now let me...
I haven't heard yet from either one of you. What was the basis that started this? What did this man claim was running in New Orleans that ought not to run?
Well...
The word racketeer means very general. What was he talking about?
when he took office, he promised that he was going to close down Bourbon Street.
That's pretty serious thing.
Well, I mean, that was his promise, and of course, that's in part of his statements. He claims that the judges blocked his vice investigations. Now, it's in this record that the judges don't have anything to do with vice investigations because the state of Louisiana, the state Supreme Court in the case of State versus Marrero has said that a district attorney is not an investigator. That in the Parish of Orleans, and this is in our Constitution and our law, in the Parish of Orleans, that the police department is the one to make these particular investigations.
You mean it's barred?
That's why he's got 12, yes sir?
It's barred from investigating crime?
Oh, absolutely not. He's got an open hearing. He can file a bill of information. He can bring witnesses before.
Have any grand juries?
Oh, yes. In the Parish of Orleans, it stays in session all the time.
When they meet, who presides over them and charges them?
The district judge.
The district judge.
That's correct.
Is it his duty to charge them about vice and crime?
That's absolutely correct. And every one of these
depended on the district attorney for that, is it?
Oh, no. But the district attorney is the legal advisor to the grand jury. And in the Parish of Orleans, he collects his evidence from the police department and brings it before the grand jury, you understand? And each one of these judges got up on the stand and said that they had denied that they had ever blocked his attempts. One of them said he didn't care. I can't repeat his word. He said he didn't give a he could close everything up on Bourbon Street as far as he was concerned because he had no sympathy for them. So that portion of the statement was absolutely false. And we put Superintendent Geruso. I'm talking about the statement that Mr. Garrison made when he said that they blocked his attempts to stimulate vice. And you see, that's where this racketeering influence becomes so important, because he says that they tried to stop the fines and forfeitures fund when the first beer drinking spot was closed down. And that raises questions of racketeering influence. So when you consider his statement together with the background of this thing, it only means one thing, that you're influenced by racketeers, you 8 criminal district judges.
General, I understood Mr. Deutsch to say that prior to the time this man was district attorney, under the law, the judges, this group of judges, or one of them at least, was in the habit of authorizing expenditures by the district attorney for the suppression of vice. That when he came in, they had the meeting in bank and decided that it would take 5 of the 8 judges to authorize such expenditures, and that thereafter they would permit no expenditures of that kind by him. Is that correct?
No, it's partially correct. Let me straighten that out for you. Well, and this is all in the record. You see, in Orleans Parish, they have a lot of extraditions. And the legislature provided that the fines and forfeitures would go to the district attorney, would be put in an account, and he would use that for the expenses of his office as for extraditions. Doesn't say anything about vice. Now, he would use that for extraditions and other general expenses. At the end of the year, he'd keep half the money himself, he'd turn half over to the city treasurer. The law also provides that he's got to file a motion with the city clerk saying that I want $3,000 for a rug. And then he files that with the clerk of the city court in New Orleans, and then 24 hours after that, I believe it is, he goes to the court, to any one of the judges, to get an approval of that particular expenditure. It's a motion, it's filed in open court, it's a public record. Now, what started this 5 out of 8 business, whether it was right or not, was the fact, and this is all in the record, was the fact that Mr. Garrison went to this retired judge to get him to approve this application for this rug, and the judge says, I think it's too expensive, give me some proof. And in the meantime, this judge went on his vacation, and he went to another judge and told this judge that Judge O'Hara said it was all right. And upon Mr. Garrison's statement and assurance, the judge signed it. And it turned out later on to be completely false. So the district attorney was playing one judge up against the other. And that's when they met with, may I say this, Mr. Black, Mr. Justice Black, may I say this? Now, before he took office, and this is in the record, he said he thought the system was bad, that the judges wanted to change it, and he agreed with it, that it should be changed. He was present at that en banc meeting and didn't disapprove or voice any objection whatsoever. And so then, when...
I started to ask, did you say one of the judges went away on vacation?
This was the retired judge. Went to Asheville, North Carolina, but that was a legal vacation because he had absolutely retired.
I believe it.
Now, and of course, that's when, let me say this, that this is in the record too, that there was some 73 motions approved by these judges during this controversy that gave him over I think, $65,000 to operate on. So how could they be blocking his efforts as to what he wanted to do if they were approving that much expenses for him? Then in addition to that, he had 12 policemen who were paid for by the city at his beck and call to use as he saw fit, to investigate, to do anything. We put the police superintendent on the stand, and he said that he picked the 12 men out. I'm talking about the defendant. The defendant picked the 12 men out, and the defendant had them, and that he hadn't interfered with their activities, that they reported to him and did what he was supposed to do. So all of that is in the record to prove that this statement that he made on November the 2nd was absolutely false. Now let me go to this question of malice. He said that they were subject to racketeering influence. On the same day, he said that they were taking vacations and that wasn't nothing but a racket. He said something about one of the judges to be charitable. He's a lie. Then he said the only way to get these sacred cows back to work is bring this to the public. Then he made a speech at a Catholic church group in New Orleans, and he got up and he repeated the fact. He says, I'm going to continue. He says, I don't care. He says, I'm not going to let any judge stop me. He says, I don't care what they say. He says, I don't care whether they wear purple robes or red robes or any other kind of robe. I'm not going to let any judge get in my way. And I call to your attention that I don't care, meaning a reckless disregard for the truth.
I don't quite finish that. I mean, he's not going to stop. Not going to stop what?
He says he's not going to stop his investigations, is what he's talking about, which the judges hadn't done, and we proved that. He again repeated that they were subject to racketeering influences. And then he made the statement, he says, I don't care what you call it. He says, that's the only reason they're subject to racketeer influences. Then he made a speech after he was, while the trial was, just right before the trial. He made a speech on television. He repeated the fact that these judges were subject to racketeering influences. And yet he told one of them privately that he didn't really mean that about him. And he said that another one, Judge Wimberly, was a real good judge. But then he gets up and makes a speech that same afternoon in which he says they're all subject to racketeering influences and there can be no other reason. And when he made the speech to the church group, he says, I'm going to continue to tell the people of New Orleans about this. He says, because I've got no organization to turn to. He says, the other officials are the Association of Armed Robbers. You mean to tell me you're going to say that, you keep saying that, you keep repeating that about 5 or 6 times, and you tell that to the public, and then to cap it all off, he made a statement after it had all happened, and that's in the record. He says, if I had to do it again, he says, I'd say the same thing. As the trial judge says.
Who was he referring to as armed robbers?
The other officials. He was talking about the judges.
Where is that in the record?
That's in the record.
I don't want to disturb you, but
that's all right. I can find it in just a second.
Just wanted to get to that part of the record. If you can get it conveniently.
I can't find it right now, Your Honor, but it's definitely in the record because it comes in the testimony of Mrs. One of the court reporters were out there and took it all down. It comes in the testimony of what? 259, I think.
259
of the record, Your Honor.
Almost halfway down the page.
Witness of the court reporter.
I have no allies because the other officials are the Association of Armed Robbers. On page 259. Almost halfway.
Of course, that was the subject matter of his speech, was his condemnation of these judges. That was what his whole speech was about. That's who he was talking about. Now, if Your Honor, please, I submit to this court that our laws are in complete accord with the decision of this court in the Sullivan case. I don't think there's any doubt about that. And this court, I'm talking about the state court that tried him, found that and proved that he was guilty beyond a reasonable doubt. He had every constitutional safeguard afforded him in the trial of his case. We were very fair about it. Judge Ponder, the trial judge, was very fair about it. And if you will read his decision, which starts, I think, on 610 of the record, you will find that it is thorough and it's complete, that his decision was based on the evidence was given by the 23 witnesses that the state produced. And there's nothing in this record that shows any of this testimony that these witnesses produced to be false. It's devoid of it. During the trial, he said he was going to take the stand himself, but he didn't. The judges got up and said that that statement was false. Judges got up and said that they had been exposed to hatred and ridicule. One of them even said that, who was a member of the New Orleans Athletic Club, he said every time he walked into the club, all the members in there started howling, "Move, move, move." Well, how much is a person got to be subjected to? And that's others had phone calls. With bad English, you so-and-so racketeer, and so forth. One of the judge's son was absolutely insulted at school. One of the pupils told this particular boy, Judge Brainey's boy, that your father's a crook, your father's a thief. That's all in the record, and none of it is uncontradicted. Not a bit of it.
Was that boy tried for
No.
under your criminal statute?
No. I might say that the defendant is a very valuable man. He talks a lot. He even said that after the Supreme Court of Louisiana rendered the decision, it's not in this case, but he said it wasn't worth the paper he was written on. And incidentally, in one of his valuable threats towards the end of this matter in January of 1963, he even predicted your decision. He said that he was going to be convicted in the lower courts, but that the Supreme Court of the land would reverse it.
Did he say whether it be a unanimous vote or...
He didn't get to that, Judge. He didn't get to that. He didn't get to that. But that's definitely, all of that, of course, is in this particular record. Well, I see.
May I just ask, Mr. Attorney General, I
Yes.
gather this is 259, this Association of Armed Robbers. That's not part of the charge on which...
No, but
this
that
only
was,
goes to malice.
That's right. That was introduced. That was evidence. We introduced all this evidence to show malice on the part of the defendant, because it was instances that related to this particular statement of November the 2nd that he made.
He made after he was charged and concerning the charges.
Oh, yes. Absolutely. Absolutely.
Well, then I don't quite... Then how... Anyway,
well,
only the issue of malice and not to any charge.
You can show malice surrounding an event by circumstances that properly relate to it, either before or after the particular incident. I think that's universal. I have no doubt about that. And the judge only allowed that for the purpose of showing malice. Now, for instance, when the judges testified that they were subjected to hatred, contempt, and ridicule, the judge did not let them say what that was, because he held that that, of course, would be hearsay, which we know is correct. And, of course, it was sufficient for the information in the charge to prove that they were subjected and that they knew that. They got up and testified accordingly.
Have there been any other charges against any other people in New Orleans in recent years?
On defamation?
For talking against judges, either federal or state?
No, I don't think so. There's been none of such a serious nature that I know of.
There have not?
There have been no such. This is the only one that I know of.
That's the only one you've ever heard of?
The only one I've ever heard of. But of course, let me say this, that all of these conferences that they had, the judges had and the district attorney had concerning this matter, the judges never got up and made any public statements. He was the only one And we proved that he made these statements deliberate, that he dictated them to this reporter, that he did it with thoughtfulness. That's all in Mr. Berthide's testimony. And that he repeated it, and he let him read it back to make sure that that's what he wanted to say. And as I say, and I mean this from the very bottom of my heart, if those judges were guilty of racketeering influence, they got no business serving on that bench. And when the state proved its case, he didn't offer any evidence that what he said was true. He didn't offer any evidence that he had a reasonable belief that it was true. And even so, the state showed actual malice in the presentation of this case, and the conviction should stand. And I trust and pray that you will reject this writ on the grounds that it was improvidently granted. Thank you so much.
Just a moment. Did you indicate that this is the only prosecution under this
defamation statute? Oh, no. We've had
this frequently used.
We had a case in Louisiana that was decided on December 16th, where a fellow by the name of Moiety defamed the district attorney, and the Supreme Court of Louisiana reaffirmed its decision in the Garrison case because the defenses there were the same as this particular case. On the same day, the Supreme Court of Louisiana reversed the case of Mrs. Webster because she was not allowed or given the opportunity to prove that her statement that she made was true. We've had a lot of defamation prosecutions, but the only one that I was, what Justice Black asked me, was there any in New Orleans other than this? And no.
In the state, about statements made about judges, either state or federal.
This is the only case, this is the only time that I know of that a district attorney has called a judge that he's supposed to cooperate with that he's under influence of racketeers.
Well, I take it there are statements in Louisiana made about judges, state and federal.
Oh, there's plenty of statements. Now, if he would have said that this court doesn't know what it's doing, or these judges don't know what they're doing, or something like that, I've heard this court criticized quite vociferously in Louisiana. But nobody has said that you're influenced by racketeers, and nobody's called you sacred cows, or said that you belong to an association of armed robbers. I've been called a lot of things in my official conduct. The district attorney supported my opponent in the last election. He got up on...
This armed robbery charge isn't what you prosecuted.
No, that was introduced to show the state of his mind that was malice. It's the only way we could prove it because he didn't take the stand.
I suppose you could file another charge on this thing.
Oh, yes, I'm pretty sure.
But in any event, this criminal defamation statute is used frequently.
Yes, very much so. There's the Lambert case, the Liverday case, the Jones case. There's about, that I know of, 25 or 30 of them.
What do you think, Mr. Attorney General, the interest of the state is in getting into private defamation?
I think that the interest of the state is exactly what I stated before, that the honesty of these men were at stake. And if they had been guilty of racketeering influence, they had no business serving on the bench. And that was the reason that the state entered this case. You see, the judges filed a... May I say this, Mr. Justice White? After he made this statement, the judges filed an affidavit in the district attorney's office. And of course, the district attorney can now process any case he wants. And he had one of his first assistants come into court and now process the affidavit that the judges made. So then the judges met en banc and ordered me to file this. That's the only way we could have done it. Because under the Constitution of Louisiana, the Attorney General has the interest of the state. He can intervene, he can supersede, he can dismiss, or anything. And I only came in there because there was no other way that we could determine the truth of the matter.
But you feel in the state has an interest in vindicating the reputation of its officials?
I do, because of the fact that if these judges were guilty of those charges, they not only were violating the code of ethics, they were violating the law of the state of Louisiana, and they should be prosecuted. And if I could have found evidence, I investigated it thoroughly, and if I could have found evidence that there was any thought of a bribe or racketeering influence by New Orleans racketeers on these judges, I can assure you I would have brought it to the grand jury and prosecuted it.
The state could have found the truth of this matter. You apparently succeeded in finding what you thought was the truth of this matter in the grand jury investigation right here.
We didn't have a grand jury investigation.
All right, anyway, you feel that you proved what the truth of the matter was. I
think so, and I think that the proof of that pudding is the fact that he made this statement on November the 2nd of 1962 falsely, that there was no truth in it, and that he did it maliciously.
Well, then why do you, but once you determine the truth of the matter, and you know that it's true, what's the state's interest in then prosecuting?
Because he had violated the law.
Yeah, but the law is being challenged on constitutional grounds,
I was ordered to do this by these particular judges, and the matter was of that great of importance.
What did you say there?
What's that?
What down, Joan, did you say?
The judges met en banc and asked me by order, would I file this bill of information? Because they were anxious to find out their racketeering influences themselves. This was a very heated controversy in Louisiana and in the city of New Orleans, and somebody had to do something about it.
Incidentally, Mr. Attorney General, have all these other prosecutions under the statute you've mentioned, have they been prosecutions for statements about other public officials? You mentioned one.
The Lambert case was a statement that a district attorney had put a guy in penitentiary, put a prisoner in the penitentiary on, let's see, what he called it on. That he illegally committed to the penitentiary on perjured testimony a certain prisoner.
And these other prosecutions, they also were for statements about public officials?
They were affirmed, yes, by our Supreme Court.
Well, is there any thought in the state's mind that you have to do this in order to avoid breaches of the peace?
Yes. Now, let me, in this Lambert case, the district attorney was defamed. And we have a procedure where if the district attorney is interested, he's got to recuse himself at the court, at the request to the court. And that is if he's interested in a prosecution, you understand? And the only person that can prosecute, the court has got to find an attorney within the district who has the capabilities of the district attorney. And then if he can't find any, he certifies that to the Attorney General. And the Attorney General can assign another district attorney to prosecute that particular case. Or I could go in and prosecute it myself, because I have that authority.
General, I notice that the gist of his complaint is that there is vice and crime and corruption on Bourbon Street in New Orleans. Is there any truth is there any proof of the fact that there is no such vice or corruption on Bourbon Street?
No, I don't make that contention, Your Honor. I'm sure that a place like Bourbon Street, that there's a lot of vice there.
But just a moment. You say they allow vice there?
No, I didn't say that. I say I presume that there is. I assume that there is, because there's been several suits that the district attorney filed that he padlocked some of the places.
Who would, if you presume that they would let it, who would do that? The police who are assigned to him, and that these judges must be his only investigators?
Somebody would evidently be lax somewhere along the line. But you see, he claims in his statement that the judges...
Would you have any jurisdiction over that?
No, I don't think so. That would be up to the district attorney and would be up to the police department.
I thought you could supersede anyone in the event.
Oh, I could go in there, but I don't make it a practice to run around the state of Louisiana superseding district attorneys and so forth unless they're actually involved, and the situation is of such gravity that it necessitates it, such as the case here. But you see, he claims that the judges blocked his investigations. And we proved on the trial of this case that the judges did not. That was false, that they wanted to cooperate with him, and that they did cooperate with him, that they approved motions for expenses, and that he had 12 policemen that could go do undercover work if he wanted, and so forth.
The policemen are the ones who have the responsibility of policing Bourbon Street, do they not?
There's no doubt about that.
No doubt about that.
There's no doubt about that.
Would they, if there was this vice and corruption there, would they be likely on assignment to him to clean that place up?
Well, I assume that they would be, yes. That would be the logical conclusion.
Even though, as you say, you assume that they permitted the vice to continue there.
With that assumption, yes, I agree.
They don't seem to fit with me.
Well, I can't change the facts, Your Honor. I mean...
you can't change the fact that there was vice and corruption.
I said in my opinion. I said, in my opinion, I assume that there was, and because of the fact that the district attorney has filed padlock proceedings on several places and has actually closed some of them. I'm trying to be as frank and truthful with you as I possibly can.
Well, he says here that now there's no question raised about expenditures until the first bee-drinking joint began to cave in.
Yes.
That's his complaint.
Yes, but he didn't prove that. He didn't prove that the judges stopped his so-called funds until that happened. That was absolutely repudiated by the testimony of the judges. That's the very point I'm coming to, that this thing was so grave and that there was this particular charge which really amounted to bribery by racketeers of the judges, that something had to be done about it. The truth had to come out. And that was proved to be deliberately false by the testimony. There's no evidence in here to show that that was even, that it even thought that. It had a reasonable belief of that.
When the judges called you in to order you to prosecute him,
I didn't have to do it.
you didn't have to.
I had that discretion under Article 7, Section 56. But as I told the court...
Did they at the same time suggest to you that by reason of these charges, they'd like for you as Attorney General to investigate Bourbon Street?
No, they did not. No one ever asked me to do that.
They wanted you
now,
to
frankly, I said it's about superseding the district attorney. In the case of Kemp versus Stanley, our Supreme Court held that the Attorney General could not supersede a district attorney who was willing to do his duty. And certainly Mr. Garrison has been working hard and has been closing up quite a few places. So I would have no actual authority to supersede him unless he had actually refused to do his duty, you understand? But...
well, he has not refused to do his duty in that connection.
No, not that I know of. But he claimed that the judges had kept him from doing this. And that was absolutely false. Because, as I said previously, time and time again, the record shows that he had plenty of funds available. The record shows that he had these 12 policemen to do his work, and that the judges in no way had ever issued any messages to him or any orders to him to stop his crime prevention work. I thank you. Any more questions?
No, I think not, General.
Thank you,
Mr.
I may have just
Deutsch. Yes.
Just a few more moments. I think I can answer your question, Mr. Chief Justice, on the record. In the first place, in the supplemental brief, question just asked a few moments ago for the second time. In the supplemental brief of the state of Louisiana on page 9, the short paragraph, the second full paragraph on that page. Prior to October 1962, expenditures from the Fund for Vice Investigations by Appellant's Office had been approved by individual judges. They had been approved. Now, page 376 of the record, one of the judges is questioned on the subject with regard to prior administrations of district attorneys. Let me ask you this, Judge, if you don't feel the district attorney has the discretion, can you point to any single case in the previous district attorney's administration that you refuse to authorize? Meaning, as you'll find in the context, these orders for investigation funds, and the answer is no, I don't remember any. So that they were always approved up to this time, as appellant said, when the bee-drinking joints began to get closed.
How long had this man been elected?
About 5 months, I think. Yeah, he took office in May, and this happened in... The statement was made in November. The record
show whether he ran on a platform of doing this, which he says he was trying to do?
I think the Attorney General made that statement. There isn't any question. And after all, it's almost a matter of public record, of which I believe you could take judicial notice if it's not in there in so many words. He ran independently. He had no political party. There isn't any statement there that he said the judges were an association of armed robbers. He says, I have no organization. My opponents are the association of armed robbers. He wasn't talking about the judges. That's a strain that language won't take. Pardon?
Who was he talking
The political organizations which had opposed him in his election. I have no organization. I have no, he says that. That's express. I'm quoting, I think. I have no organization. My opponents are the Association of Armed Robbers, meaning the professional political organizations which had opposed him in his election. He was elected.
Other officials.
Pardon?
He says,
Or it may be the
officials.
official.
Other officials are the Association of Armed
I think, well, I didn't have it before, but the sentence before that says, I have no organization.
Turn to, yeah.
And that follows right with it. I have no organization. The other official are the Association of Armed Robbers.
You think the saving was what people usually call a machine, but they want to beat it?
Certainly.
At least. If they were bad people and he was a good man.
Well, I don't think there's any question you could ask him. He would answer that question affirmatively.
Mr. Deutsch, how long was he in office before this judge attacked him for congesting the calendar?
He took office in May. This controversy started 3 or 4 months later. That's as close as I can give it. The statement, which is the subject of this, was the subject of this prosecution, was made on November 2nd, published on November 2nd, as I recall it. He took office in May. Now, there had been a building up of the controversy and statements back and forth. When the retired judge made his statement, charging appellant with responsibility for the backlog of these cases, that wasn't the first thing that was said on this subject. It had been going back and forth.
Very well.
Do you think it's makes any difference whether this statement that he made be read as an attack upon these judges in their official rather than their personal character?
Well, I think the judgment must go with me in either event, but I do think it makes that difference because it brings it under the scope of what we have called sedition in the last 175 or 180 years.
Attack upon them solely and exclusively in their official capacity.
Would make it sedition in the, shall I say, appropriate sense. Now, I don't know whether it was an offense for him to make the statement as to what he thought this court would ultimately do in this case. I certainly have had my very strong views, and I ask you to support it.
Mr. Chief Justice, may I say one thing?
Yes, General.
What Mr. Deutsch is just saying now about organizations, that's his interpretation of it. But he, the district attorney, never did explain that. And there's nothing in the record to show that he was talking about a political organization. So I don't know what he was talking about, but I do know that he was in a controversy with these judges, and that was the subject matter of his speech at that particular auditorium.
Yeah, very well.
This is Our Hidden History